I mentioned a petition for motion malady yesterday. It could not be listed. And we allowed to do it today, malady.
You didn't file it yesterday.
Malady.
You did not file the matter yesterday.
I sent it for filing, malady. Due to lack of filing number, malady.
Please, Lordship. But I wish to mention for listing of repetition method, that is already numbered method. Tender meta method.
Maybe.
Lordship, in item 21, we have filed our affidavit, I may refer.
My lord, we have also filed one additional affidavit, my lord.
May I please, Lordship? I beg to mention item number 4, Lordship. Lordship, this matters pertain to a division bench, but wrongly has been listed this single bench, Lordship.
He's not a devoter.
Yes, Lordship. No, the voter, FT case, the voter.
Okay, we declared it foreigner. That's written that.
Item number 4, the registry is directed to list this matter before the approved bench.
Applies, Lordship.
Please, Lordship. I beg to mention for vacation listing, vacation court listing
Okay.
on 8.
Huh?
On 8. 8 of,
Ten.
yes, 8 of October.
10th is vacation bench.
Yes, vacation bench on 8 and 9.
Mention then.
May please, your Lordship.
Vacation bench is not going to give in.
Already beg to mention item number 12, malady. That is a contempt petition, malady. Order has been complied, malady.
Already payment has already been made by Latuba, and he has also received man.
Complied.
Contempt complied man.
Order dated.
Order dated, Lordship.
Order dated 27/8/25.
Last date.
Passed in
Repetition number 453 of this.
453. Sorry, 13/5/25. Order
We'll
dated
take when the
13/5/25.
matter is taken. We'll close it then.
For motion item 1.
Yes, Mr. Sharma.
May please also. The petitioner is a contractor and he was allotted a work to a Z+2 RCC building at Jorhat. That was, and the amount was fixed at rupees 3 crore 71 lakhs. And the site was not handed over to the petitioner. He wrote several letters. And thereafter the plan was modified.
This is for cancellation of the shed.
Yes. The cancellation of shed,
You were granted a shed.
no. Shed was there. Now, I was granted a contract for construction of Z+2 RCC building. Where the plot was occupied by one Bordolo gas agency.
Okay.
That that could not be evicted. Therefore, the plan was changed, and it was revised, and the amount also enhanced up to rupees 4 crore 93 lakhs.
Where is your contract?
These are the
No, where is your contract?
Additional affidavit.
Where is your work order?
An additional affidavit, my lord.
Right, it's now construction of Wenzo. This was given in 2020
2020,
to be completed within 18 months
3 months.
in consultation with so and so after execution of the work. Okay.
And my lord, as the
So after that, what has happened?
the site could not be handed over to the petitioner. Thereafter, could not be handed over to the petitioner. Thereafter, they revised the plan. So, Lordship, kindly turn to page 38. It is of dated December 2023.
Then,
Then, my lord, when I am went to the office for allotted the site, then thereafter on 4th August, they cancelled my contract, my lord. That is at page 41.
what is wrong?
No, there is, my contract was allotted a way back. Thereafter, I asked for the to give the land so that I can do the
Understood,
construction.
everything is understood, but the fact remains that the possession of the land could not be handed
Yes.
over. Contract was given to you in 2020
But thereafter,
and till 2025, they have not handed over the land to you.
no, they have got the another land nearby of that land, and they changed the plan. Whole plan has been changed, and thereafter that page 30.
Now you want that contract should remain so that you can again construct in that
Yes.
land which is yet to be vacated.
No, they have allotted separately,
So there the
keeping
contract,
the
there the
keeping
contract should be applicable
yes.
at the same rate.
No, it's a rate they have fixed at for
No, no,
Okay.
3 crores.
no, your lordship, page 38.
Yes. Where is,
Estimated amount, your lordship. Please.
now you should be given this particular contract.
Yes,
This is a separate contract.
it is not a separate contract. It is
Absolutely, that is a different plot of land. Everything is different now. Schedule of rates have changed. You have to participate. This has to be by way of a tender. That other one has been, by doctrine of frustration, has become not viable.
no matter the earlier contract tender was not cancelled. It was modified. It was modified
No, it
as
couldn't be in that same place. It has to be in the other place. You give an undertaking that you will do this particular contract, then I'll at rupees 3 lakhs so and so, then I will take up this issue with them. You agree to that rate
Yes, ma'am.
as per your work order. You say that okay, you will do the work at 3 lakh 66,079, 3 crores 66 lakh 79,000.
but page 40 your lordship can be seen. This is my this is letter to the petitioner.
This is written by them.
It is
Thereafter, they have gone for cancellation on
yes.
the basis of a meeting which was held on scrutiny committee.
Yes.
Okay.
Madam.
Now they want to go for a fresh one.
Fresh. So way back in
That- because the land has changed, change of design and structure,
yes.
change of schedule of
Rate,
rates,
everything changed.
time delay in implementation of the earlier tender.
Yes, everything changed, madam.
Everything changed. Why should this court?
And it's
okay?
2020 and now it's a last.
No,
year of-
therefore I'm saying,
Ma'am.
if they are willing to do the math, work at 3 crores 66 lakh 79,000, whatever may be, this court can issue a notice on an undertaking that they would do the work at 3 crores.
Already cancelled, my lord. So since already cancelled,
That is, cancellation is not without any fault on the part of the petitioner.
No, it is not your fault. There's no quarrel that there is a fault on you. But the thing has, everything has changed. The
Right.
rates have changed because the rate at which it was given must have been earlier because the rate which is now being applied is as per the 2021.
20.
Your work order is of the year 2020. Nothing remains.
Yes, my lord. And whether he can complete, my lord, in that amount of money, my lord, probably because of inflation, my lord.
No, that cannot be done because
Ma'am.
everything had changed. Now
Lordship,
the earlier area where the construction was, that has changed.
change.
The rates have also changed.
It will be new one, my lord.
The new one,
My
you
lord,
give an undertaking to them, they will consider that I can at rupees 3
Even
crores.
if they-
56.
they-
Obviously, government will.
My lord,
be
I'll take instruction. Even if, my lord, they give undertaking, whether they can complete, my lord,
At the old rate,
the whole rate,
which obviously you won't.
not be, my lord.
Okay.
Saxophone.
Huh?
It's saxophone. Saxophone.
my lord, in that case, I maybe some time to get instruction. Whether
Mr. A.C. Sharma, the Lunatic Senior Counsel, submits that he would like to obtain instructions from his client. Or he'd like to obtain instructions. This is the matter of the vacations.
Applies.
Item 2,
Ms. Yu Das appears on behalf of the residents.
This is my non-payment of contractual liabilities.
How much?
It's my 5. Item to 5 lakhs, my lord. Out of 5 lakhs, 3 lakhs has already been paid, my lord.
When
Remaining,
it was paid.
remaining is 2 lakhs, my lord. And extra A, my lord. At the time of allotment of the work, my lord, first installment was disbursed.
Hmm?
At the time of allotment of work, my lord, first installment was disbursed, my lord.
This was done in 2018.
Yes, my lord.
You had to complete the work within how much time?
Within June, my lord. We have completed within June, my lord.
June
2018 only.
2018.
2018 only.
Then why you are approaching this court so late? And enclosing our order of 2019, that person was very, have to take it after 7 years.
Yes, my lord.
Then
Yes,
why
there
you
is some delay on the part of the petitioner, my lord. There is some delay on the part of the petitioner
Then?
approaching.
on this ground, one should not issue notice.
But otherwise, my lord, funds are lying with the council, my lord. Funds are lying with the council, my lord.
Understood, but you didn't want to. They may not have problems in finding out as to whether you have worked or not.
That is not very difficulty because, my lord, in the meantime, my lord, there is some litigation, my lord, and records were seized by the court, my lord.
What litigation?
Regarding, my lord, their functioning, my lord. So in any case, my lord, records are there and funds are also lying with the council, my lord, as per I know, my lord. Yes, it is admitted that there is some delay in the part of the petitioner.
উপরে কি লিখে দিব? একটু নোটিশ ইস্যু করবে লিখবা। One and by registered as well as by speed post during the during the course of the day. Step for speed post. Returnable on 12th of January 2026. Affidavit to be filed by 5th of January 2026. Taking into account that the petitioner had approached this court after the completion of the work in the year 2018, it have approached this court in the year 2025. And the payment of the and the entitlement of the petitioner arose in the year 2018. The question of delay and latches, maintainability of the petition on the question of delay and latches is kept open. For regulation.
Obviously. Item 3 and 5 are similar one.
All 2018.
All 2018. Obviously.
Yes, Mr. Sharma.
Yes, Your Lordship, my lord, this is a case, my lord, where we are praying for refund of MDRR and MDFT. Actually, what happens, my lord, petitioner was a settlement holder of a mining contract, mining permit, my lord, for a period of 2 years. Recently, my lord, 29/4/2025, the permit expired. My lord, he has deposited 10% MDFT and, my lord, MDRR. So, my lord, as far mine closure plan, since it's a riverbed mining.
Lordship, here they're saying that this MDRR, this fund, which he has
It is the
deposited.
requirement as per the rules.
But
isn't
the
it?
requirement as per the rules. Is a requirement as per the rules. You have to deposit it. And he's saying that this one extraction, after extraction taken place, the riverbed automatically fills up the silt. The automatically gets filled up. But this MMDR fund is not only used for that only, Your Lordship. There are certain conditions and clauses out there, whose MMDR funds are used. And even when he was asked to deposit, he deposited it. That's the issue, Your Lord.
Now he wants the refund.
Now he wants a refund.
That it is not,
Because he knew the mining closure well before the extraction of the sand.
after the mining is over.
After mining over, he's seeking for this 10 refund.
Well, I think you should be entitled to some cost
Lordship,
from the petitioner.
this is like the notice for a lot.
Show me the provision by which it can be refunded.
My lord, progressive mine closure plan, my lord, I am submitting, my lord, lordship may kindly
No,
see.
where is the provision by which?
Provision is not there, my lord, for refund of provision is not there. My lord, may I
No, the
submit, my lord?
rules are
Actually, what
saying
happens, my
here
lord?
that there is a requirement
my
of
lord-
this MMDR thing.
MMDR means, my lord, what happens, my restoration and reclamation of the area.
Yeah, some mine and concession rules from this.
My lord will kindly see the page 22, this is the mining, mine closure plan enclosed in the, my lord, mining plan. Mining plan is prepared as per 52 of the rules, my lord.
No. I mean,
As
for
part
that,
as-
but once you deposit, can you ask for refund? Show me that unless you challenge the provision. Where is the
There's no provision for a lordship.
rule?
Kindly look at rule 58.
Rule 52, my lord. As per rule 52, I have deposited, my lord.
No, where is the option
As
of
per
getting the
settlement order
refund?
also, I have to deposit, my lord.
Rule 52?
52, mining plan, my lord. Sorry, my lord, 59. 59, lordship will kindly see 59. I have stated in my paragraph, my lord. 6.
An amount equal to 10% of the dead rent or so and so. Or contract money paid as it shall be charged from the mineral concession holder in the nature of other charges for restoration and rehabilitation works and credited to the fund in addition to the amount payable to the petitioner. Shall be remitted by mineral concession holder in installments along with installments of dead rent. Such amount shall be reconciled at the close of demand and any differential of the amount shall be adjusted or paid. Department shall maintain complete account of the receipt of the fund and the expenditure therefrom, and shall invest the progressive cumulative purpose in a manner so as to earn secure returns thereof. So. you have to
MMDR,
challenge-
my lord, MMDR, this is the
No, you
MMDR. my
have
lord.
to, Mr. Sharma, unless you challenge 59P. You have to challenge this rule. Otherwise you can.
Then, my lord, DMFT, 10% DMFT, my lord. 10% DMFT also
rules.
deducted, my lord.
That is the rules. If it is any payment is to be made, it is as per the rule. You paid it at your.
My lord,
without any
for
quarrel.
DMFT, there is no rule, sir. The lordship judgment is there, my lord. In a similar matter, my lordship holds that DMFT cannot be deducted and that is to be refunded.
But we are concerned with this.
MMDR, my lord, so far MMDR, my lord, I have, my submission is this, my lord, since restoration reclamation is not required as per mining plan. So why the amount has been
No, then you have to
collected from me?
challenge 59(3). Because 59(3) is open worded. The department shall maintain complete account of the receipts to the fund, and the expenditure therefrom shall invest the progressive accumulated corpus. So means there is a bigger corpus that will go to that pool in a manner so as to earn secure returns therefrom.
Return therefrom.
So
That is true, my lord. That is true.
Okay.
My submission, that, my lord, that is there, my lord. And my lord.
Moment
for
the MMDR
DMF
fund was asked for him, he deposited, your lordship. He
DMF
carried on
also I have
the, he
deposited.
carried on the extraction work. The period is over. Now he's coming to claiming refund of the MMDR fund.
DMFT.
And his only ground is that this riverbed gets filled up by itself. Naturally.
No case.
DMFT lordship's own judgment is there, my lord, for refund, my lord.
But that is different. We are concerned with them.
MMDR, my lord, so far MMDR lordship will pass appropriate order, my lord.
You are asking for the other also.
Other also, my lord.
Where?
DMFT also. My lord, prayer is there, my lord.
DMFT. What is that? DMFT. What is show me that. Where is my judgment?
My lord.
For reclamation and restoration work and 10% for DML. Additional being minerals from the mines and if they given it and reliable.
Yeah. Oh, yeah. Agreement to approve. So we just, Vishnu protein bora. Vishnu protein bora. 2024 1 GLR 316.
So there is nothing in the contract for payment of DMFT.
I have deposited, my lord, as per their direction, my lord.
But there is
3
nothing.
lakhs 44,000.
But the contract they have done annex. Is there any clause of?
Well, settlement, my lord, lordship will kindly see.
We do.
Contract means, my lord,
No,
I have to
that's
file
all.
the contract, my lord.
We issue notice.
Lordship will kindly see.
We issue notice on the limited aspect of
Only DMF.
4,504 as the
DMF.
DMFT,
Right.
not on respect to
Right.
the MDRR.
My lord, my lord, my lord.
Sure. Issue notice making it returnable on 3rd of November 2025. Mr. R.R. Gogoi accept notice on behalf of the respondent numbers 1, 2, and 3.
Right.
Extra copies of the petition be served upon him during the course of the day.
My lord.
At the outset, Mr. J. Sharma, the learned counsel appearing on behalf of the petitioner, submits that taking into account the judgment of this court in the case of Vishnu Pratim Bora versus State of Assam and others, reported in 2024 1 GLR 216. The petitioner herein would not seek for refund of the amount of rupees 3,44,504, which the petitioner deposited as in terms with Rule 59 of the Assam Mines and Minerals Concession
2013.
Rules 2013. The learned counsel for the petitioner, however, submitted that as the petitioner were directed to deposit the amount of rupees 3,44,504 apart from the deposit the petitioner had to make in terms with the MDRR and the said amount having been received without any authority of law, the amount of rupees 3,44,504 deposited by the petitioner towards the, what is that D?
DMFT, my lord.
Huh?
DMFT.
What is that D full name?
I could not collect, my lord.
Huh? You must be knowing. You have been
Gogoi
charging money right, left and center. You even don't know under what head you are doing it. Huh? In on a to DM fund. Ought to be refunded to the petitioner. The respondents are directed to bring on record the stand as to whether there is any provisions under the Assam Mines and Minerals Concession Rules 2013, the agreement entered into by and between the petitioner and the respondent authorities, as well as the letter of intent for the purpose of charging no, letter of intent was agreement and the agreement they entered into for the purpose of charging an additional amount of rupees 10% to the tune of rupees 3,44,504 on account of the DM fund. Listen.
Obliged.
District Mineral Foundation Trust.
DMFT.
He also doesn't.
It's a non-profit body established under the Mines and Minerals Development Regulation. It's an.
Item 7.
What does this person have to do every time another case? Huh?
Wait, Your Lordship.
Huh?
Every time he will come and when the situation is not favorable,
Hmm.
he'll accuse me of being biased.
What has happened this time?
Yes, Your Lordship, there is a clause in the tender document.
Last time I passed one order, na,
Yes.
one person.
Yes.
Nice, Lordship.
He
Then what
became
happened now?
L5. He became L5.
Huh?
He is now L5, the nice. So he is not in the, he didn't, if he was L1, then Your Lordship's order would have operated. But now he's L5.
Now what do you want?
Yes. So now what is the, there is a clause in the tender document, Your Lordship, which says that if the L1 has participated or is a non-MSME, then they will follow the price preference policy for MSME. That means they will not get the entire 12. They will get the 75%, which is 9 out of 12. And rest 3 will be given to MSME.
You are L1.
I'm L3.
Now you want preferential because you are an MSME.
I'm MSME. Now,
Now why didn't you raise that issue in your earlier writ petition?
that time the price bid was not open, Your Lordship.
So you knew about that,
Yes, he has,
that you should be getting preferential treatment as MSME.
that will only come if the L1 is
Now they have not given you the preferential treatment.
not only me, the other non-MSME also. Because the rest 3 will, they will then have, there's a procedure prescribed how they will give the rest 3 to the MSME. But they have not even followed that procedure. My case is that. Because if Your Lordships come to the tender clause, Your Lordship. Because otherwise I come in the zone of consideration for the remaining 3.
Is
Page
your,
six-
MSME?
yes, page 61, Your Lordship.
Page
61.
Now, where's your certificate? MSME. MSME certificate is where?
No, they have, your lordship will come to page 139.
Yes.
139 technical evolution, IR number 7.
You are?
Number 7, technical evolution. That MSME is there.
Then there are a lot of MSME.
Yes, this number 6 is who is L1. Is non-applicable. So he has been evaluated as a non-MSME.
Okay, then.
Then if your lordship sees a financial bid also next page 140, L1 this NK Sharma, below him nothing is written. Whereas in number 2, 3, all number 2 MSME social category general, MSME is written. Number 3 is MSME is written. And since your lordship, we don't know what documents they have submitted because the entire
Where MSME written?
if your lordship sees serial number 2, ABC, below that MSME.
MSME.
I am number 3, MSME.
Ah.
So your lordship now, they have this tender process has not been transparent because we are not being able to see the documents that they are uploaded. So my case is that he has been technically qualified or evaluated as non-MSME. He may be MSME and non-MSME, I don't know. But in this tender process, he has registered himself as a non-MSME.
Who?
This L1.
Ah.
So now since his L1 is non-MSME, he is entitled to only 9 of the units. Rest 3, they have to follow the non-MSME MSME price preference policy.
Have they given the entire 12 to number?
Now they have given the entire 12.
Where?
If your lordship see the last page, 146. 146, the last page. The bid has been awarded to him. All.
How do we know?
That they will confirm that this is 12.
Huh?
Because otherwise we don't have any document. Entire 12 has been given to him.
How do you know? Where is it?
The bid award is status bid award.
So it may be also given to them also.
All 12. Because your lordships, what happened? Your lordship sees that if your lordship come to page 141, I have been sent an email to match the price because I have to match the price of the L1. 141, your lordship. So this email was sent to me to match the L1 price.
Provided you match the L1 price.
I did. But before I could do that, they have on the next page, they have withdrawn it also. On the ground that his bid is evaluated as an MSME bidder.
Who?
The L1. Because he has given Udayan certificate.
So he submitted the MSME bid.
But he has registered and participated as non-MSME in the tendering process. And he has submitted or not, that is just their statement. We don't know because you're not being able to see. The entire tender process has been in dark. So he may have a tender Udayan certificate.
Okay,
but willing,
your clause.
Yes.
On which you have filed the case.
Your page 61, your lordship. 61.
Yes.
29.1.1, Roman 1. In case participating MSMEs quote price within price band of L1 plus 15%, such MSMEs shall be considered for award of contract by bringing down their price to L1 price in a situation where L1 price is from someone other than MSME. In case of more than one bidder, so rest of
in case participating MSME
is more than one.
Prices the price band of L1 plus 15%.
Yes, I come within the 15%.
Because you are number 3.
Number 3.
So you come within 15%. So you are to be given equal to another L1 who is not an MSME.
Yes, that's my case.
But if he is already an MSME, then you don't get the chance.
Then I don't get the chance. But my case is that he has participated.
Okay, you file your reply.
Yes.
Lordship, I can, now also I can demonstrate, Lordship.
Then now only I dismiss.
But
and forbid Rajiv Hazarika, this petitioner, from filing any further petitions. This is the 4th. Every step they are coming before this. And also Mr. R. Sharma and R.B. Fukan. They are the persons who have been doing it.
Lordship, this is the bid participation document of L1. That is respondent number 5, Lordship. Lordship may kindly come to the next page. Supporting document for last page, next page, last line, Lordship. Supporting document for EMD exemption uploaded. There is a document, a PDF document, Lordship would see.
And what was the last date of submission?
Last day, this was submitted with the bid. This was
What
submitted
was the
along with
last
the bid.
date of submission of the bid?
18/8, Your Lordship, 18/8.
These documents were submitted later on or
Se-
what?
17/8, Lordship. No, not the last page, Lordship. Last page is the second page, Lordship. Kindly come to the second page. That is the bid submitted by the petitioner. Lordship would see the date 17/8/2025. And the last line, second page, last line, supporting document for EMD exemption uploaded. This is the document, Lordship.
This is the document.
That is the document.
This was submitted on
This is
that
submitted
date,
along with the bid.
17/8.
17/8 itself, along with the bid, Lordship.
So he is an MSME
He is an MSME,
and
Lord-
he has also sought for
EMD
EMD
exemption,
which is given to MSME.
MSME, and he also asked for MSME preference. Lordship, what happens when I submit the bid, I upload all these documents and there is a checkbox. I have to tick that I am opting for this preference. Sometimes what happens, the L1, he did not click the box, but I can show you the manual things which he has. I'll show you the checklist. Lordship, may I kindly see the checklist. Lordship, may kindly come to page number 52 of the writ petition. Clause 8.2. Clause 8.2, Lordship. Submission of checklist and bid matrix duly filled in. Has your Lordship got it? Second line for
Claim.
52, second line, Lordship. 8.2 clause.
So here you therefore say this particular clause 29.1.1 cannot be made applicable
No.
because this particular person who is L1 is already an MSME.
He is an MSME. He applied as an MSME and evaluated as an MSME because EMD we have already given exemption. Since he did not click in the box, his name is not shown as MSME and there is a shortcoming in the portal, Lordship. We cannot do it ourselves. If it is not clicked, he was not shown as MSME and we cannot change it. As a buyer,
But
we
the
cannot.
fact that he had uploaded,
He uploaded it.
he had claimed exemption
Yes.
is a fact that on the basis of which it was held to be technically qualified.
Yes, Lordship.
Then on the basis thereof, it should be taken that the tendering authority has accepted him as an MSC.
MSC. And he has accepted the EMD also. No EMD was paid, Lordship.
Okay, let me write the judgment. The last dismissal today. Mr. R. Sharma, the learned counsel appearing on behalf of the petitioner.
P. Borua.
P. Borua, the learned counsel who appears on behalf of the respondent numbers 1, 2, and 3. And 4. To stop. The petitioner herein is aggrieved by the actions on the part of the respondent authorities in granting the entire contract for hiring of service for 12 numbers scrapping winches, winch units for Assam set for 5 years to the respondent number 5 without taking into consideration clause 29.1.1 of the
Annexure 1.
instruction oblique information to the bidders, which is annexure 1 to the bid document. Taking into account that it is the petitioner's case hinges upon clause 29.1.1, the same is reproduced herein under page 61, only 1.1. Following mane goteটো কৈ নালাগে 1.1 খালি এই বুলি এটা দি In the backdrop of the above, it is relevant to take note of that the petitioner herein the case of the petitioner herein is that the petitioner participated as a MSE enterprise. It is the further case of the petitioner that from a perusal of the technical evaluation as well as the financial evaluation of the respondent number 5, it does not appear that the petition respondent number 5 was evaluated as an MSC enterprise. Mr. R. Sharma, the learned counsel, appearing on behalf of the petitioner on the basis thereof, submitted that as the L1 bidder, that is the respondent number 5, was evaluated as was not evaluated as an MSC enterprise. The respondent authorities were required to abide by clause 29.1.1, which stipulate that if the MSC enterprise, if any MSC enterprise quotes price within the price band of L plus 15%, such MSC shall be considered for award of the contract by bringing down their price to L1 price. In a situation where L1 price is from someone other than an MSC. Referring to the documents, referring to the technical evaluation, as well as the financial evaluation of the respondent number 5 at annexure 4 and 5 to the petition, Mr. R. Sharma submits that the respondent authorities have all along treated the respondent number 5 as a non-MSC enterprise, and as such, however, the respondent authorities, the learned counsel appearing on behalf of the petitioner further submitted that this aspect of the matter would be further clear from the fact that after opening of the price bid, the petitioner was also asked to submatch the bid of the L1 bidder, that is the respondent number 5, by the communication dated 11/9/2025. However, on the very date, the state offer so given to the petitioner was withdrawn, and the contract was awarded to the respondent number 5. You were given when?
On 11/9, then they withdrawn on 11/9. I match it on 12. Again, I was given an opportunity on 13/9. So that is still pending.
That means that we were given twice the opportunity on 11/9/2025 as well as on 13/9/2025, as would be seen from annexure 6 and 8 to the petition. However, the same was withdrawn and the respondent number 5 have been awarded the contract. Mr. P. Barua, appearing on behalf of the respondent numbers 1 to 4, however, submitted that the respondent number 5 at the time of submission of the bid had submission of the bid of his bid on 17/8/2025 had applied as an MSC enterprise And this aspect of the matter can be seen from the bid participation document of the respondent number 5 and the supporting document enclosed for EMD exemption. The learned counsel submits that the EMD exemption is only granted to MSC enterprise. The learned counsel further placed before this court the supporting document which was submitted for EMD exemption, that is the Udayam registration certificate of the respondent number 5, dated 15/12/2021. In addition to that, the learned counsel appearing on behalf of the respondent authorities further submitted that at the time of submission of the bid in the electronic mode, the respondent number 5 may not have ticked the concerned box, but the physical document which was submitted in terms with clause 8.2 of the information to the bidders. What is that? Information 8.2 of the
Page 52.
50,
that I know of the instruction of the information to the bidders, which is annexure 1 to the bid document. It is apparent that the respondent number 5 had applied, had claimed purchase preference under MSC. It is therefore the submission of the learned counsel appearing on behalf of the respondent authorities that clause 29.1.1 cannot be applied to the facts of the instant case. The documents that have been placed before this court during the course of the hearing are kept hearing. That is, number 1, the bid participation document, the Udayam registration certificate, and the checklist are kept on record and marked with the letter X, Y, and Z respectively. This court have duly perused the materials on record and have as well as the documents which have been placed, kept on record and marked with the letter X, Y, and Z. Copies of such documents have also been handed over to Mr. R. Sharma during the course of the hearing. From a perusal of the said documents, it appears that the respondent number 5 all along participated as an MSC enterprise. First, upon such participation, and in that regard had also enclosed, uploaded the Udayam certificate certifying that the respondent number 5 is a MSC enterprise with effect from 15/12/2021. 15/12/2021. Considering the above, it is therefore the opinion, considering the above and reading clause 29.1.1 of the information of instructions to the bidders, it is the opinion of the which have been quoted herein above. It appears it is the opinion of the court that the said clause 29.1.1 cannot be applied in the present facts and circumstances, taking into account that the respondent number 5 was an MSC enterprise and had participated as an MSC enterprise. Considering the above, this court does not find any merit in the instant petition for which the petition stands dismissed. However, in the facts of the case, no cost.
Supplementary item 14.
No more, huh, Mr. Sharma? Enough of winces. Sometimes the winces that N becomes T and becomes a witch. So don't move. This is the fifth order at convinces. Yes, what is this? Oh, this incorrect.
Received the instruction, man.
Raise your senior. But the instructions are such that senior have gone. As per top page of tender document, download from the internet, so and so tenders are compulsory required to submit the certificate as per Annex 5 of the tender document. Without that, the offer will be considered incomplete and will be submitted. Accordingly, the petitioner uploaded the compulsory certificate in Annex D. Copy attached Annex 2. During scrutiny, it is found the petitioner had tempered, modified the standard format of Annex D as per the tender document. We noted that as per the Annex A submitted by the petitioner, if the bidder tempers or modifies the tender form, the downloaded from the tender would be submitted. So that is.
Page number 2, my lord. Downloaded notice there. Page number 2, my lord. Note.
What is that?
Note.
Tenders are compulsory required to submit a certificate as per Annexure Roman 5 of the tender document. Without that, the offer will be considered incomplete and will be summarily rejected.
Yes, ma'am.
Next,
my lord, page number 5.
this is the certificate
Yes,
Annexure
my lord.
5.
And
What has he given?
in paragraph number 8, my lord.
That if the contents of the certificate submitted by us are found to be false, or incorrect at any time during the process for evaluation of the tender, it shall lead to forfeiture of the bid security. No. Madam, if I remember, Mr. Sahewala was making a submission that the hard copy which was submitted
Yes, my lord.
was okay.
No, the soft copy that was onlinely uploaded,
Was
that was
okay.
okay. The hard copy that was submitted, that has some alteration.
So,
And in terms of the,
copy was okay.
yes. And in
That was
terms of the
submission.
notification,
But we have that copy, my lord, that page number, the downloaded copy, my lord, that is page number 5, my lord, para number 8, page number 5.
Here, it is different. Paragraph number 9, na?
Yes,
No.
paragraph number 8, my lord. Paragraph number 8, my
It is same.
No, my lord, it is different from the Annexure 5, my lord, that is mandatory provision.
The hard copy.
Yes, my
It
lord,
is different.
different, my lord.
But is the soft copy in terms with
Annexure 5.
Annexure 5?
My lord, that is as per the instruction, my lord, that is in first page, my lord. That is his instruction is in page number.
Compulsory required to submit a certificate as per Annexure 5 of the tender. Without that, the offer will be considered incomplete. Uploaded the compulsory certificate. During it was found that the petitioner had tempered, modified the standard.
Downloaded copy, my lord, as per instruction, my lord.
That as per Annexure J submitted by the petition, if the bidder tempers with the information. No, my only question is
Yes, my
whether the bid which was submitted online
Yes, my lord.
is in terms with the format.
No, my lord, kindly see, my lord, kindly see in accordingly, the petitioner uploaded the compulsory certificate Annexure 5 as attached as Annexure 2 during the, so it was found that petitioner tempered and modified, my lord.
So the online was wrong
Wrong, my lord.
and offline.
Offline, my lord, that is modified. And online, my lord, there is a declaration, my lord, in online. That is in last page, my lord. Last page, my lord. Last page, there is a declaration from the contractor, my lord. We have downloaded the tender from internet.
Wait. Now, in all both the documents, it is mentioned the same.
No, yes,
No,
my
no.
lord.
But he has uploaded and given the online, both are same.
Yes, my lord.
Because there, if you see the word or incorrect
Yes, my lord.
has been added
Yes, my lord. And yes, as per the format, my lord, that is,
and may also lead to any other action provided in the
Yes.
contract.
he did not
That has
add
been
this one, my
inserted.
lord. To any other action provided in the contract, my lord. That is missing, my lord, from the format, my lord.
Now, in this certificate, annexure 5,
Yes, ma'am.
page 5. What is wrong is to be false or
My lord,
false
listen, para 8.
or incorrect.
It shall be lead to the forfeited of the bid security and may also lead to any other action provided in the contract. That is missing, my lord.
Where is the annexure 5 now?
Annexure 5 is page number 7 and 8, my lord.
Input verified on any or
In paragraph
at
page,
any time during the process for evaluation. Then during the process for evaluation. Madam, this particular document, page 5 is the uploaded one.
yes, my lord.
There also or incorrect is there,
Yes, my lord.
both pages. We should notice, let them file. and-
Yes, yes, ma'am.
Private facie not successful. Issue notice making it returnable when you file your,
After vacation, my
we
lord.
make it subject to the outcome.
Madam.
You notice making it returnable on 24th of October 2025. Means AGI accepts notice on behalf of the respondent numbers.
Yes, all the respondents, my lord. Yes. Oh, no, sorry, 1, 2, 3, 4, my lord. 5 is,
5.
5 is private.
As regards the respondent number 5, extra copies be served upon her during the course of the day. As regards the respondent number 5, the petitioner is directed to take steps by way of speed post during the course of the day. As so the petitioner is further given the liberty to take steps upon the respondent number 5 by way of thusly routed to the registry of this court and file an affidavit of service on or before the next day. The petitioner herein is aggrieved by the rejection of the bid of the petitioner, technical bid of the petitioner.
Page 56.
In terms with the communication dated, in terms with the communication dated
56, my lord, page.
22/9/2025, isn't it?
My lord.
Annexure Roman 6 to the writ petition. The case of the petitioner herein is that the respondent authorities have issued a notice inviting tender dated 12/6/2025 for construction of cut and cover tunnel on pile foundation with touch piles on both sides between CH 39457-39492 and cut and cover tunnel bracket open foundation between CH 39492-39620 as slope protection measure in connection with Dimapur bracket Hansari dash Kohima bracket Jubra new BG railway line project. The petitioner, in pursuance to the said notice inviting tender, participated in the said bid process along with various other bidders. Full stop. The petitioner was informed by the communication dated 22/9/2025 that the techno-commercial bid of the petitioner was rejected, was found to be technically unsuitable on the ground of altered format of annexure Roman 5, para 8 submitted by the bidder, that is the petitioner. Being agreed, the present petition has been filed. The matter was taken up by this court on 24/9/2025. When Ms. Again, the learned counsel representing the respondent numbers 1 to 4, submitted that she would obtain the necessary instructions. Full stop. The case of the petitioner. What listed on the case of the petitioner herein is that admittedly the petitioner have not provided the format, provided the certificate as per annexure Roman 5 of the tender document. But that mistake was committed by the petitioner only in the offline mode, but not in the online mode. In that regard, the petitioner have given a detailed comparison at paragraph number 5 of the petition. The instant marriage petition was taken up for motion on 24/9/2025. On the same date, this court inquired with Ms. Again, the learned counsel appearing on behalf of the respondent numbers 1 to 4, as to whether the contention of the petitioner that the offline mode, the certificate in annexure 5 was correctly submitted in the online mode can be accepted. The learned counsel submitted that she would obtain instructions. Accordingly, the Ms. Again has placed a set of instructions issued by DY.SCE/CON/DMV NF Railway Dimapur dated 25/9/2025. The said instructions are kept on record and marked with the letter X. From a perusal of the said instructions, it appears that it prima facie appears that both the certificates submitted by the petitioner in the offline as well as the online mode do not tally with paragraph number 8 of the format prescribed in annexure Roman 5. Considering the above, this court therefore is not inclined to stay the further tender process. The respondents are directed to bring on record their stand by filing the affidavit, including the documents which have been placed before this court and kept on record and marked with the letter X. The said affidavits be filed on or before, when did I file? Public schools, huh? 24. On or before 17th of October 2025. This court, however, observes that any steps taken towards the finalization of the tender process shall be subject to the outcome of the
Much obliged.
I'm not staying it.
Yes, madam.
Subject verb.
Must oblige.
Item 15.
Not please, Your Lordship.
Yes,
In
but
this case, my lord,
none has appeared. What is your case?
But my technical bid has been rejected. But at page 105,
Which department?
but this is infrastructure.
AIDC is the main
AI.
party here, madam.
Where is
Assam
the
Indus-
AIDC?
Assam Industrial Development Corporation Limited.
My lord.
AIDC, that lawyer is there, na? JK Goswami.
My lord, now probably my lord Satyajit Das, S Das, Surojit Das, my lord. The other day he filed the affidavit, my lord, on behalf of, in another
There's
case.
no standing counsel.
Standing.
In infrastructure, there is.
AIDC had a standing counsel, if I remember. I was taking one matter.
So for infrastructure.
Infrastructure, they have, my lord, but not Assam Industrial Development Corporation. There's another infrastructure
This
development.
is
corporation.
AIDC only.
Lodge.
AIDC, this is.
Another one is my lord,
This is
infrastructure.
the one at RG Burwa Road,
Lodge.
near the Doordarshan.
Lodge.
Oh.
Okay, tell me. None has appeared, so what will do?
Copy
We'll
probably
pass
has
on
not
those
been
in-
served because they.
Well, if there is standing
No,
counsel
today is the
copy-
last day. You want to call them, call them. That is your
My lord,
call.
probably
No,
copy-
they cannot be
Whether,
denied their benefit because of some lawyer does not appear.
not whether copy was served upon them, whether they have knowledge on, upon, regarding filing of these cases, my lord.
What department? Your government appoints a.
I am here, my lord. I have no.
Okay, let us hear Mr. Spike. What is your case?
my lord, page 105, my lord, the rejection of my technical bid on the ground that due to non-fulfillment of NIT RFP criteria.
Rejected due to non-fulfillment of NIT RF
Lodge.
criteria. What is that?
My lord, but nothing has been
Isn't it too
specified.
vague?
Very vague, nothing has been
Vague.
specified. Page 51, in fact, your lordship will find.
Has it been given to anybody? Technical is open, then financial?
But the financial, my lord, though as per the tender clause was to be, my lord, open subsequently with due intimation of the date to the, my lord, successful bidder, but it was open on the same date. And respondent number 1 has been judged as in, my lord, L1
Who?
at respondent number 5, my lord.
He's going to.
Respondent number 1.
And how much is your bid?
Yes, my lord, his bid is, my lord, 12 crore 55 lakhs and odd, and my bid is 11 crore 65 lakhs and odd. So thereby, my lord, more than 90 lakhs are differences. 90 lakhs differences there. Had my technical bid been, my lord, declared responsive, I would have been
But tell
L1.
me, Mr. How are you going to serve on these visual associates?
My lord, I have made a, my lord, statement here because detailed particulars are not there, so therefore, my lord.
You cannot say that. Pavitra Boro Guwahati. Means you don't want to serve.
No, my lord, the addresses are not there. Through, my lord, we have made a statement through the, my lord,
It
the
cannot be
AIDC.
so.
In that case,
It
we'll.
cannot happen like this. Type of how is
We'll
it
give a
possible?
paper declaration in that matter.
Paper declaration, okay. If you go for a paper declaration, we'll issue the paper declaration, then stay. This can't happen like this. You cannot, you must be knowing it. You see, I'm telling you why. In these address, opening and pay for a committee members of the. This is your technical price bid.
This is
Annexure I is your price, financial.
annexure I is the price bid of the successful bidders. Annexure J is my price bid, my lord. Page 120, my price is at page 127.
Yeah, we approached this court at the last moment.
The addresses are not available, my lord, in the website also. We have inquired. my
You
lord, they also-
knew about it earlier. I could have very well asked them to get the instruction in Datika. How do you state if you move in the last date?
They'll furnish us the, my lord, addresses will serve, my lord.
Who will punish you?
My lord,
You
the,
don't have the AIDC council also. Where is that order?
my lord, there's no order as such, my lord. The
Fine.
LOA has not been issued as yet, my lord.
Is there any standing council? Let's find it out. We'll take it up at night.
He has inquired from the filing section. There's no standing council as such. For the infrastructure development corporation, there's another is there. Their standing council is there.
AIDC has.
Yes.
Mr. Sharma, AIDC has, nah? Who is he?
Surojit
We'll
Dasar.
wait for some time.
We'll have it at 2. If he comes, I can ask him to get that instruction also by 2.
My lord, prior to.
We'll take the matter after some time when he comes. You have your. We can get some instructions, then we can proceed. But the order means they should give some reasons,
Lord,
not there.
Lord,
Yes.
because already financial bid has already been open as per my senior has stated.
That is why he has come.
My lord, so
After having coming to know that he's
Now it's-
lower 10 only.
today is 8th day, my lord.
Item 16.
Yours, Mayor.
Mr. Das, you do one thing. Take a copy from him
My lord,
and just your AIDC.
my lord, yeah, it is.
Just find out why it was rejected. We'll take it up at 2. That's motion. Why it was rejected.
My-
Because there's no reasons assigned there. Just reject.
Technical bid was rejected.
Why? Which clause has not been done? Just get your information. We'll take it up at 2.
My lord. Thank you.
Give a copy to him. Yes, madam.
Please, Your Lordships. My lords, may I read the impugned termination notice, Your Lordships?
Okay.
This is, Your Lordships, at the notice starts, Your Lordships, at page 35, but I'm on page 57, Your Lordships.
57.
Please, my lords. All the references are given before that. The notice itself starts at page 39, my lords, where a mention of this show cause notice of 15 days period is given.
Termination notice.
Please, my lords. If for a moment, my lords, I may refer to the 2 dates before this notice.
Yes.
On 2nd of June 2025, a cure period notice was given to me, which is prescribed under the contract clause 21, my lords. I gave a reply to that on 1st of August 2025. Meanwhile, your lordships, on 22nd of July 2025, my contract was extended up to 31st of July 2026 in view of the reasons which I had given in the cure period notice also. There was also a development, your lordships, last year on 21st of March 2024, because this was a contract which was a linear contract and there was no requirement for an environmental clearance, my lords. Thereafter, a judgment came, your lordships, of Honorable Supreme Court, by virtue of which in all these contracts also environmental clearance was mandated, and I could not even lift earth to proceed with my work, your lordships. This had a cascading effect on the contract, and this change of law led to this contract becoming unviable in the present conditions. So once this order had come of the Supreme Court, your lordships, there was a change of law situation, which I intimated, and they are still considering it. Meanwhile, your lordships, contract has been extended, a change of scope, my lords, has also been allowed, by virtue of which this contract has been enhanced by an amount of 56 crores. And then bang out of the blue, I received this notice of 26th of August, 2025, your lordships, which is sent to me by email. It is around 300 pages long notice, my lords, which is sent to me. I am unable to download it, but meanwhile, I write to them on 9th of September saying that I may be given some more time to respond to this. In any event, I gave a response on 16th of September, 2025 to this particular notice. Now, my lords, the termination notice comes immediately on 17th of September, 2025. And without adverting to my response at all, your lordships. Paragraph 8 of this notice now may be seen in the light of this background, my lords, which is at page 58, my lords, of the paper. In view of the above, the authority reserves the right to proceed with issuance of termination notice without further correspondence, Any further representations, if submitted, shall not be considered and without prejudice to the authority's right under the EPC contract. So on one hand, your lordship, the reservation of right is created. Now, your lordship, in the same paragraph, they say, thus the contract hereby stands terminated. That's on 17th of September. They don't give reference to my 16th of September detailed response, my lords, where I have highlighted that you have not only extended the contract. After cure period notice, I gave a reply on 1st of August. So the termination of contract for cure period is not there. And now suddenly they are seeking to use another clause of the contract to terminate my contract. Now, in this background, your lordships, I will take the honorable court to clause 4.3 of the EPC contract. This is at page 187, my lords.
Yes.
My lords, we start from page 186, which is obligations of the authority.
Environmental and forest clearance are not required for the.
In bold, highlighted, clear terms. Then, your lordships, in 4.3, your lordships, at page 187, again, last line, environmental and forest clearance are not required for this authority represents and warrants that environmental clearance and forest clearance for the project is not required. Now, in view of the change of law where an environmental clearance has been mandated, my lords.
In the event of any delay, the contractor shall be entitled to time extension for a period of such delay in accordance with the provisions of Venture.
And damages.
Can also be entitled to damages calculated as if the right of way and
clearly, your lordship. And this issue is still under consideration by them. And suddenly, your lordship, bang out of the blue, they come ahead and they terminate my contract. Cure period notice on 2nd of June 2025. Within 60 days, my reply on
your immediate relief.
Your lordships, not to give effect to the consequence of this, because based on this termination, they are seeking to encash my bank guarantees, your lordships, and forfeit the same.
Now we'll stay the bank guarantee, but
My lords.
otherwise we cannot, otherwise termination cannot be.
I'm obliged to hear.
We'll stay the bank guarantee and till the next day.
Lordship, I will take instruction in this matter.
Huh?
I will take instruction in this matter. Lordship already terminated.
No,
This is-
therefore,
yes,
we are not
Lordship.
staying the termination.
Lordship.
Only stay is towards the encashment of the bank guarantee.
Bank guarantee also, Lordship, in case of termination, it automatically, the authorities become.
No, whether the termination is illegal or legal is another aspect of the
Lordship.
matter.
Lordship.
The question is, here is a case where in clause 4.3, there is a categorical mandate to the effect that there will be no requirement of an environmental clearance.
Lordship.
Now, pursuant thereto, there is a judgment passed by the Supreme Court in this
Mrs.
noble M. Paikada. So in that judgment, it is stated these projects also would require environmental clearance. Now thereupon, what has happened? If you see clause 4.3 further, if necessary, you will give time extension, and further, there would be further amounts would be paid to the contractor if there is a requirement at a later stage. This is a consideration to be looked into only in the aspect, not for setting aside the termination order. Termination has happened, whether there is a legality in the transfer or not, for invocation of the bank guarantee is the subject matter which this. Otherwise, they can go in terms of, I think, 62 of the GCC.
Please, Lordship, arbitration.
So that they will do it on that basis if they want. But only thing is, if it is illegal, then there needs to be a stay to that. Only on the legality of the termination. Otherwise, they would be entitled to damages. Termination.
They have not even replied to the notice, Lordship, of 15 days notice.
Which
It has
one?
15 days notice, Lordship, at page 57. It is specifically stated that 15 days so cause notice was issued to them on 26/8 to
2025, para 7, Lordship, page
You repeat that
57.
15 days to post notice was duly served upon article 11.
We have replied.
Part 1, Lordship. No representation or substantive reply was received within the stipulated time frame, thereby constituting a clear breach of contractual obligation and procedural timelines.
My lords, what my learned friend is saying, it was not.
Finally come to your subsequent letter dated 9/9/2025.
Yes.
Sent by the same email on
It may on 10.
10/10. 10/10 is yet to arrive.
Lordship.
What is this?
It is on 10/10/25, 10/10.
10/10 is yet to come.
Maybe it is 10/9, Lordship.
Huh?
Yes.
On date 10/9.
Sent by same email on that. Maybe it is 9.
My lords, we had given a reply, annexure I.
Yes.
On
Lordship.
16th of September, we have given a reply. What my learned friend is saying, that there is a stipulated period of 15 days.
15 days.
It says, your lordship, the contract clause says may reply within 15 days. It isn't that automatically the reply comes on the 16th day, they can terminate only on that point, which is what they're seeking to do.
It is stated
I
like
have given a reply on 16th of September, my lords. They did not even advert to that reply.
You
What is
gave
that?
on 16 or 9/9.
Your lordship, on 9/9, I wrote to them and also sought that for a detailed response, I need some more time. I gave them 2 responses, my lord.
Where can I find those?
Your lordships. My
This-
lords, this is annexure I, 16th of September.
Okay.
My lords, this is at page number 933, my lords, of the paper book. And the termination letter is 17th of September.
933.
Please, your lordship.
This 16/9. This is your detailed reply.
Please, my lord.
This is of
And
16/9.
this was not taken into consideration.
This is just not taken on consideration. By this letter, they sought additional time, Lordship. Same cannot be entertained as a valid response under the terms of the contract agreement. As no provision is given for providing additional.
No, the question is whether you would have, whatever may be, the question is that your action has to be fair, isn't it, madam?
Look,
So, whatever may be, one is somebody has given period to your,
Page 933 to 952 is my detailed reply, your lordship.
and which one is the earlier one,
Your
9/9?
lordships, my apologies, my lord, that may not have been attached because it was an extension of time letter which we sought, also saying that your termination is illegal. But that was only a 1-page email we had written to them, my lords.
You have not enclosed that?
I will just, no, my lords, it's been at 6:24, your lordship.
Anyway, you should.
No, that is the extension of time.
Okay.
It should. It should. Actually. I will place it on record, your lordship. We have a soft copy.
Issue notice.
so otherwise also they have not submitted the representation within the time limit. As per their own
I
objection,
also
it is 6.
understand that,
Lordship.
therefore I'm not staying the termination. alone.
Lordship, yeah.
I'm only
It is
saying
just
the
to arbitration.
yeah, of the bank guarantee. I don't think that the railway heavens will fall.
Bank
I
guarantee also, Lordship, as per the agreement,
No.
No,
on
I also
termination
know
of
what
the
is the
contract,
agreement.
Lordship,
We'll see to that.
they can encase it.
Issue notice making it returnable on, when can you file your response?
2 weeks, Lordship. 2 weeks after vacation.
27th of October,
Lordship,
2025. Ms. RDP accepts notice on behalf of the respondent number 1, 2, and 3. Extra copies of the petition be served upon her along with petition, along with the documents enclosed therewith be served on her by during the course. The petitioner herein is aggrieved by the communication dated 17/9/2025, by which the contract was terminated by the respondent authorities, and further steps are being taken for invocation of the bank guarantee. Which have been kept with the respondent authorities in the form of performance security and retention money. It is the case of the petitioner that the petitioner was awarded the contract for engineering, procuring and construction of the BG formation, including side drains, retaining walls, other protection works, minor, major and important bridges, RUB LHS, station building platforms, FOBs, development of circulating areas, and other passenger amenities, including electrical, general works for commissioning of doubling of BG railway track between Katiyar and Umidpur. In the said contract, amongst the various terms and conditions, clause 4.3 of the scope of the project of the scope of the project, that is part 2 of the bid documents, stipulated related to environmental and forest clearance. The said clause being relevant is reproduced herein under 4.3, 4.3, 187 and 188 selected. Schedule. A perusal of the above quoted clause categorically shows that the project in question, that in respect to the project in question, environmental and forest clearance was not required. It further stipulates that in the event of any delay, the contractor, on account of environmental and forest clearances, the contractor shall be entitled to time extension for the period of such delay in accordance with the provisions of clause 10.4 of the agreement, and shall also be entitled to damages calculated as if the right of way for and in respect of such sections of the new BG railway line project have not been provided in accordance with the provisions of clause 8.2, and as a consequence, the contractor shall be entitled to damages under and in accordance with the provisions of clause 8.3. Pursuant to the solid contract, which was awarded to the petitioner, the work continued. However, the Supreme Court, in the case of Noble M. Paikada versus Union of India, reported in 2024, 12 SCC 363, observed that, where is that paragraph, madam?
Please, yes. The paragraph of the book. Noble one. Well, it's page 8, your lordships, it has been given. So, Noble.
In this judgment, where?
In the judgment, my lords, in the last paragraph. Are we going to copy to the board? Your Lordship, paragraph 41 to 43, Your Lordship, they have stated that item 6 and amended impugn notification. Accordingly, we quash item 6 of the two notifications.
When the Supreme Court observed that there would be a requirement for environmental clearances in terms with the directions passed by the learned National Greens Tribunal. There would be environmental clearances required. First, the undisputed fact, the materials on record further show that on account of the said judgment passed by the Supreme Court, steps were being taken for carrying out environmental clearances by the respondent courts. In such circumstances, admittedly, there has been certain delay, which the petitioner claims is entitled to. Petitioner claims that the petitioner is entitled to extension in terms of clause 4.3 as referred to herein above. Be that as it may, the respondent authorities had issued a (15-day) show cause notice dated 26/8/2025, whereby the concerned authority conveyed its intention to initiate termination proceedings, and the petitioner was advised to submit any representation within the stipulated period of 15 days from the date of such issuance. It is the further case of the petitioner that on 9/9/2025, a request was made for granting extension for submission of a detailed reply. Immediately thereafter, on 16/9/2025, the petitioner submitted a detailed reply. However, without considering the detailed reply dated 16/9/2025, on a mere technicality that the petitioner did not submit the representation within 15 days, the impugned termination letter have been issued. Madam, I think I'm right with the.
Please, Your Lordship. Please.
The learned counsel appearing on behalf of the petitioner submits that if the respondent authorities would have considered the detailed reply submitted on 16/9/2025, wherein due details have been provided, the respondent authorities may not have issued the termination letter. The non-consideration of the communication dated 16/9/2025 violates the rights of the petitioner under Article 14 and 21 of the Constitution, inasmuch as the principles of natural justice have been violated. The Learned Counsel submits that taking into account that the order of termination dated 17/9/2025 have already been passed, the petitioner would not ask for would seek an interim direction as regards stay of the said order of termination. However, pending notice, the consequences which would befall upon the petitioner on the basis of the order of termination dated 17/9/2025 be stayed. Ms. RDP, the Learned Counsel appearing on behalf of the respondents, submits that she would have to obtain necessary instructions. She further submitted that one aspect is very clear, that the order dated 17/9/2025 duly contained detailed reasons for which the petitioner's contract have been terminated. She further opposed submitted that no interim directions be passed without giving an opportunity to the respondents to place the necessary instructions. This court have given a detailed consideration on the materials on record as well as the order passed by the Supreme Court in the case of Noble and Pakadia Supra. From the materials on record, it appears that there was initially, when the contract was awarded to the petitioner, there was no requirement of any environmental or forest clearance. In view of the judgment passed by the Supreme Court in the case of Noble and Pakadia Supra, the necessity has arisen for obtaining the environmental clearance. This court further takes note of that the petitioner had duly submitted a request on 9/9/2025, which is also mentioned in the termination order dated 17/9/2025, seeking a further time for the purpose of submission of a detailed reply. The petitioner further had submitted a detailed reply on 16/9/2025. The said reply, however, have not been considered, as it's very much apparent from a perusal of the termination order dated 17/9/2025, inasmuch as there is no reference to the reply dated 16/9/2025 of the petition. Considering the above, this court is primacy of the opinion that the non-consideration of the reply dated 16/9/2025 in the facts and circumstances of the case appears to be in violation to the principles of natural justice. According to this court also cannot be unmindful of the fact that a termination order cannot be stayed. And as such, the question of staying the termination order does not arise. Be that as it may, this court, however, directs the respondent authorities not to invoke the bank guarantee. Number, what is the number, madam?
Your Lordship, Last page.
Lordship,
It's mentioned in the prayer clause, your lordship.
Huh?
Mentioned in the prayer clause, my lord.
Yeah, yeah. This is the number. Page 1781.
Please, my lord.
Are you sure? This is, I think this one, no?
My lord,
14 crores, this one.
14 crores, your lordship.
Bank guarantee, VG number 330605. Direct the respondent authorities not to invoke the bank guarantee. Being VG number 330605 2601 LG 001523
Please, my lord.
amounting to rupees 14 crores 83 lakhs issued by the Punjab National Bank MG Road, Tejpur, Assam branch till the next week. Isn't that?
Please, my lord.
Yes, that is the
Lordship, one thing, the representation dated 9/9/25, Lordship, it was emailed on 10/9/25. Here, Lordship, they seek the additional time and it was considered and it was stated that the additional time cannot be granted. It was later on, Lordship, on 16 and detailed representation has been filed and it is not considered. And secondly, Lordship, regarding the Supreme Court order, it was most probably not brought on record, Lordship, earlier, therefore it was not considered. Earlier, it was a.
saying the termination.
Yeah, yeah, Lordship.
Do whatever it is. Till the next date, I'm just saying the bank guarantee.
Lordship.
No heavens will fall. You'll get the money whenever you feel like. In fact, this is the case. Once you get that instruction, then you will pass the order.
Alright.
You file your affidavit by, it gets within next date, it is 27. You click on 27. No? You file your affidavit by 22nd. 27. Affidavit be filed by the respondents on or before 22nd of October.
Alright. I'm deeply obliged, Lordship.
May I please, the Lordship? Lord, the issue in the petition is very small issue, my lord. The petitioner was settled with a fishery, my lord. And right from the beginning, he could not operate the fishery due to encroachment and illegal fishing, my lord, which are part of record, my lord. Now, my lord, subsequently, he has returned to the authorities to hand over the possession back to the authorities, my lord. And now, my lord, the authorities has issued a letter by taking cancelling his settlement order, but implicating to initiate the partidary proceeding against him. So my limited prayer is that, my lord, my representation may be considered, my lord. I am not going to run the fishery, my lord, but my representation may be considered. And after that, whatever decision they take, my lord, they may take. And for ready reference, I would like to show before your lordship some relevant documents who will show that right from the beginning, my lord, the petitioner could not operate the fishery. Initially, my lord, the petitioner was issued a fishery settlement proposal letter on 4/11/2022, which your lordship will find as Annexure 1, page 19. Then, my lord, before issuance of the final settlement order, the authority themselves filed a complaint before the concerned police station at page 25, my lord. Page 25, initial proposal letter was issued on 4/11/2022. Then on 16/11/2022, before issuance of the final settlement order, the authorities themselves filed a complaint before the
No, wait. When the proposal was given to you,
Yes, my lord.
did you put a complaint that there are encroachment?
Yes, my lord.
Proposal was initially given, not the settlement.
Yes.
Did you raise any objection?
No, my lord, because at that point of time, I was not aware that illegal, because illegal.
No, you were therefore given the proposal.
Yes, my lord.
Then why did not you say that, okay, we are not going to take it? It's a proposal. Why didn't you say that I don't want to take it? There are encroachment. The fishery has dried out. there are local agricultural activities going on.
Yes, my lord.
This didn't happen on that day, or did it happen when
It,
you have taken the possession?
After taking possession, my lord, subsequently we came to know,
And
my
did you
lord.
file an FIR?
Yes, my lord. I have filed an FIR at page 4, my lord. Page 4, sorry, annexure 4, page 26. My lord, that was registered as Abhayapuri police case number 281 of 2023, my lord, under section 147, 325, 506. And the details your lordship will find at page 27, my lord. On clause number 12, on 18/6/2023, the complainant Kaushik Ranjan Das, the writ petitioner herein, son of so-and-so, lodge an FIR at Abhayapuri PS to the effect that he have seen signed.
No, this is only for that. This happened only on 16/6/2023.
Yes, my lord.
Okay?
Yes, sir. My lord.
There's no encroachment.
Yes,
There's no
ma'am.
allegation of encroachment in this FIR.
Yes, ma'am.
They snatched your gold chain and also assaulted you.
Yes, ma'am.
Where's the allegation of dispossession?
My lord, that is the bill to inquire whether any illegal fishing is going on or not.
And prior to that, you have said that some disputes of possession in some specific area.
Yes, my
going
lord.
on.
Yes, my lord.
Okay?
So, yes, that all
Now,
those.
now, why did you see, kindly see, most of the, after being handed over the possession of Iman, I come to know some disputes. You were issued a letter,
Yes,
proposal.
yes, my lord.
You did not look into it.
No, my lord.
Now, later on, you found out.
Yes, my lord. After I deposited the required money, security money, and all I deposited. My
You
lord,
should
my
not have deposited.
yes, ma'am. My limited prayer is that, my lord, I have filed several representation, Annexure 5, then Annexure 7, Annexure 9, and Annexure 10, my lord. And lastly, Annexure 11, Annexure 10 on 11/8/2025.
So you have nothing against the termination.
Yes, my lord, no.
You are as regards consideration of the representative.
Yes, my consideration of the representation until then, my lord,
If you would have, if you would have annexed the NIT lordship, then you would have no case lordship, because
Huh?
he would have no case lordship. We would have the NIT conditions lordship. There we have specifically stated that they cannot claim anything, every encroachment, the flood relief, and here they have signed an agreement also lordship.
Where you in it?
In agreement also they have signed it, that they will not claim anything.
Where is your agreement?
agreement is.
Where is your NIT?
NIT agreement, again agreement, they have specifically signed that they will not claim anything for any encroachment.
There's nothing out there. And you even in your letter of 22/2023, which you have mentioned out there,
Yes, my lord.
you say that on 4/11/2022, I was given this proposal. Thereafter, I have taken over possession and found that there are disputes.
Yes, my lord. My lord, my limited prayer is to
When
let,
were you handed over the possession?
my lord, the final settlement order was
No, when were you handed over the possession?
after issuance of the final settlement order
When
on
was the final settlement?
1/12/2022.
Where is that?
Annexure 2, my lord, page 22, my lord.
24.
My lord, regarding the cancellation, I don't have issue because I myself submitted representation to surrender the fishery. my
Where did you come to know about this annexure 3?
Annexure 3, my lord, subsequently, I got a copy of
Where's
the,
your statement out here?
that is not there, my lord.
Then, if you know that because on 4/11/2022, you were given a proposal,
Yeah.
whether you will take it or not, you have the document of 16/11/2022, which is annexure 3.
Yes, my lord.
Thereafter also you have accepted. Why?
Yes, Maybe it may be a fault on my part, my lord, because I was on the belief that the actions will be taken by the authorities, my lord. But subsequently, the things
Then you
did
should
not.
not have taken it. You knew about this thing.
No, I thought that, my lord, the things will be sorted out, my lord, and the
Annex
problem.
3, what have you mentioned? Put to your knowledge. Records.
Yes,
Did
my-
you hear that after issuance of the Iman, he accordingly approached the judge for taking action against the same. Subsequently on Iman, have written here. See, kindly come to paragraph 4.
Yes, my lord. And
What do you say?
my lord,
No,
because
no. Here you see.
yes, my
What do
lord.
you say? Read paragraph 4.
Yes, my lord, I have read.
No, read paragraph.
The
You have a
petitioner
case.
noticed that illegal fishing was continuing in the said purpose.
No. After issuance of the proposed settlement order dated so and so,
Yes, my lord.
the petitioner noticed
Yes, my lord.
illegal fishing was continuing in so and so, and he accordingly approached the responsible for taking action on the same.
Yes.
Subsequently, on the month, I have filed it before the officer in charge in the area. Then why did you take it?
Because
You knew about all these things.
yes, I saw that they were taking action, my lord, at that point of time. And they assured me that, my lord, it will be sorted out.
Where? Where is your statement? to
That is not there, but but I saw that, my lord, they were taking my lord, I myself is surrendering
When is the vacation bench sitting?
on 9th and 10th, my lord.
We have it on 9th and 10th, better off. Not before me.
My lord, only my consideration of my representation, last representation, my lord, at page annexer 10, page 37, only regarding the consideration, let them consider whatever order they want to pass, they may pass, my lord. Let them consider my representation because the facts which I have stated, my lord, in the representation, let them pass a order on my representation, my lord. That is my limited prayer. Because I myself have surrendered the fishery to the authorities, my lord. By this representation itself, I express my willingness to surrender the fishery.
Where is your representation after that? After that order, where is your representation?
After that, first order is first
They
representation.
have considered your representation or not considered, but they have passed an order. After that, where is your representation? I should direct them to consider.
After the passing of
Yes.
the impugner,
is that?
after that, there is no representation, my lord. Because before passing of the impugner,
I can only pass an order
yes, my lord.
that Mr. D.P. Bora submit that the petitioner would submit a representation before the respondent authority against that impugning order. And if the petitioner is not, and thereupon I will pass an order that therefore he wants to withdraw the instant petition with the liberty again to approach this court if the representation goes again.
Yes, my lord. That will.
You understand?
Yes, my lord. That.
Third, Mr. D.P. Bora, the learned counsel appearing on behalf of the petitioner. Mr. P. Sharma appears on behalf of the Assam Fisheries Development Corporation. And Ms. Yudas appears on behalf of the District Commissioner, Bongaigaon, as well as the Superintendent of Police, Bongaigaon. The petitioner herein is agreed by the order dated 9/9/2025. And the learned counsel appearing on behalf of the petitioner submits that the said order has been passed without considering the representation which have been submitted by the petitioner before the concerned respondent authorities from time to time. This court inquired with the learned counsel appearing on behalf of the petitioner as to whether pursuant to the order dated 9/9/2025, the petitioner had submitted any representation. The learned counsel appearing on behalf of the petitioner submits that the petitioner is not adverse to submitting a representation detailing out all the facts so that no further steps is being taken for the purpose of initiating Bakizai proceeding. The learned counsel further submit that taking into account that there has been a lot of encroachment in the fishery in question, the petitioner would not however, seek any restoration of the cancellation order. Because taking into account the above, liberty is given to the petitioner to file representation before the managing director of the Assam Fisheries Development Corporation. This court further observes that if the petitioner is aggrieved by the non-consideration of the representation or the representation decided against the petitioner would be at liberty to approach this court.
My lord, a time limit for consideration of the representation.
How can I give it? You are not have yet submitted.
No, I will submit within a stipulated time and thereafter, after submission of the.
That is why I'm saying that the petitioner is given the liberty to liberty.
Yes,
But for non-consideration as well as if the consideration is against.
Yes, my lord.
Give it.
Yes, my lord. Obliged, my lord.
Obliged.
Where is the lordship?
What is this?
No, the petitioner has challenged this particular NIT, my lord, which is Annexure 1.
Lecture?
Annexure 1, my lord. Page
Law
50
e-auction notice. What is
page,
this?
I had participated in it.
Mr. R.R. Gogoi, what is this? I've heard of short
And
petition, short
law-
notice, short e-auction.
Now it is a long notice.
Long e-auction.
Long.
Have you ever heard of?
No, no. Short is different, it's a long one.
The long e-auction. Okay, then.
Now, my lord, in this notice, your lordship kindly come to page 22, my lord. There is a clause which was inserted for visiting of site, my lord, in the bid document. At page 22, the part of the bid document, my lord.
Yes, clause?
At clause 6, at the bottom.
Yes.
No,
Site
no.
visit.
Yes, site visit. The bidders may undertake the site visit to concession area at their cost and risk to ascertain for themselves the site condition, location, communication, climate, availability of power, etc. Then, my lord, 6.2, this bidding document does not, however, give the unconditional, unrestricted right to access, consideration. That is for extraction or prospectus. That is it. 6.3, in the event a bidder undertakes a site visit, then such bidder shall be liable towards any loss or damage caused to the site and the persons having surface rights over the concession area on account of any act or omission of such bidder or its employees, authorized representative, etc. My lord, in other words, my lord, this clause was, my lord, it is a provision, my lord, to protect the rights for both the, my lord, the participant or the bidder, or and the, my lord, the employer or the tenderer. My lord, so that, my lord, to avoid.
Later on.
Yes, nothing
don't have a
happens.
case like Mr.
That previous case, my lord, that preference. Exactly, my lord.
Yeah, then.
And then what happens, my lord, in the kindly see my site verification notice, that is at page 25. This is done in presence of their officer, my lord. This is issued by the range forest officer. Page 25. This so far as the petitioner is concerned.
Yes, then.
And the photograph, which is geotagged. Next page, my lord. Then, my lord, there is a letter from the authority at page 27, my lord. 10/9/25, my lord, informing us the names have been given, my lord. At top, my lord, 1, 2, and 3 are the private respondents in this writ petition. 4 is the petitioner, and 5 is another one, my lord. They said that you have technically qualified. Now the fact is, this first 3 didn't qualify technically to the extent that, my lord, they have not submitted this site verification certificate. So that is the case, man.
Huh?
This was, my lord.
You are technically qualified. Then
I am technically qualified, my lord. But these 3, my lord, 1, 2, and 3, they are not.
Why?
Because they have not given this site verification certificate.
Is it required?
Yes, but this is requirement. The clause 6. Clause 6, clause 6. Page 22, man.
Bidder may undertake
site visit
to concession at their cost and risk to ascertain themselves of the site conditions, so and any other matter considered relevant. The bidding document does not, however, give the unconditional or unrestricted right to access the concession area or so and so. The site visit must be in compliance with the applicable law of the person having surveyed. The bidder undertakes to visit, then such bidder shall be liable towards any loss or so and so having surveyed area. But it doesn't say that it is
Exactly.
required to be.
My lord,
It doesn't say that there is a requirement to have the site visit certificate.
my lord, they may have used it, my lord, the niceties, my lord, like saying may, my lord.
Huh? No.
There's a specific clause given that you go, you visit.
You see the what is the language used by PWD?
No, they also say, my lord,
Says that there has to be a site visit certificate to be signed by the concerned engineer, and without that site visit certificate, the tender would not be accepted.
that is not, but in so many clauses, that is not said that in violation of this, the tender shall be, or the bid shall be cancelled.
There it is, there, not here. Okay.
My lord, it also says, my lord, the site visit must be in compliance.
9/10 or today?
My lord,
Today is the last day.
Last day.
Last day for this matter.
my lord, my lord, the clause says, the site visit must be in
But
compliance.
Mr. Gustami, either you go for 9/10 or you go for today. I finish it up today. Because 6 does not.
My lord, I have also submitted an objection, my lord.
Very good.
Your lordship will
Well,
find
that
that
objection has no relevance.
page 29,
Because
my lord.
Clause 6 does not mention that there is a requirement of a site visit certificate.
My lord, even the other clauses also do not say so, but we take it that, my lord, those must,
Please don't take it.
my lord.
You don't please take it.
It also says, my lord, that 6.2, your lordship will kindly see, my lord, that the site visit must,
Clauses are worded in such a manner that if you go there, you may go. But if you go there, you have to pay also. If anything happens.
Exactly.
Why will anybody go?
my lord, their own officer, they have deputed their own officer in case of the petitioner and another, my lord, but so far,
Good. They are doing their work. But that doesn't mean that it is necessary.
my lord, my humble submission, my lord, this is essential for both the parties, my lord. And
Mr. Gusmi, I
It-
really don't convert this court to the authority. It's for them. They will know whether it is required or not.
It doesn't
Let
say the
let
bidder.
bid open.
my lord,
Yes.
Finish.
To,
He will get-
one
no,
of,
no, that they have not declared the
just said-
result of the financial.
we have not uploaded, I had just taken instruction, LO has not been issued till yet. One of the parties, has been given this highest bidder, has been declared as the highest bidder. This, for now, the name I have not been provided. There are either Dhaneshwar Rabha or Sushanta Rabha. One of Dhaneshwar Rabha or Sushanta Rabha, one of them has been declared as the highest bidder, Your Lordship.
What is the name of the petition?
Both of them have
Both,
been.
I'm not saying both of them. I'm saying
No, no.
in between these two, one of them has declared highest.
Anyway, no change. Nothing. So we dismiss you.
Oh, nine. Yeah. Oh, what time is it?
No.
But if they take,
This-
well, let them produce the records. Well, he's saying from.
How is it?
He is challenging the clause 6 only. He's saying that we are the
Records or no records?
others in a complex clause 6 doesn't say about submitting site
Immediately
verification.
on reopening, man. Immediately on reopening, man.
Matter becomes infractual.
I have made them parties, my lord. I have also filed objection to it, my lord.
Even most probably
In
the
the
petition.
meantime, the order will come.
Yes.
Your lordship may make it subject to the
No.
result of this situation.
No, only, therefore I said there are two orders. I'll fix it after vacation or 9th or 10th. There might be a better judge. Or now you take a dismissal. Whatever you feel. On the
Open
eve
the
of the
window,
Puja,
open
would you like the dismissal or better the face being withdrawn? Which one?
Well,
Mr. Goswami, which one?
my lord,
9, 10.
I'm thinking because vacation, my lord, I will not be here, my lord.
No, anyway, after vacation, it becomes.
No, it will be too long, man.
Now, you see, once the notice
Alloy.
contract is being awarded,
My lord,
this becomes infructuous.
my lord.
You have to then challenge them.
The decision, my lord.
Question of giving it subject to outcome does not arise in view of clause 61626.
My lord.
Let me dictate.
Well,
Heard Mr. Goswami, the legal counsel appearing on behalf of the. Mr. RR Goi appears on behalf of the.
Question 1, 2, 3 and 4.
The present writ petition has been filed by the petitioner challenging the technical challenging the communication dated 10/9/2025, whereby the private respondents numbers 5, 6, and 7 have been held to be technically responsive. The ground on which the petitioner alleges that the respondent numbers 5, 6, and 7 are not technically responsive is on the ground that the said respondents have not complied with clause 6.1, 6.2, and 6.3, which, as per the petitioner, on the basis of which the petitioner further contends that the site visit certificate is mandatory while submitting the bid. This court finds it pertinent to take note of clause 6.1, 6.2, 6.3, clause 6, as well as finds it pertinent to reproduce clause 6, which along with its subclauses, page 22 and 23. From a perusal of the above three clauses, it is apparent that there is no mention that the site visit certificate is required to be a part of the bid document. The part of a document to be submitted by the bidder. So under such circumstances, the question of the private respondents being disqualified or being not eligible for not submitting the site visit certificate is totally misconceived. Accordingly, in that view of the matter, this court does not find any merit in the instant writ petition for which the writ petition stands dismissed. In the peculiar facts of the case, this court is not inclined to impose cost.
Obliged, Lordship.
What is the
My lord, I have been running a shop, my lord, since 2022. And suddenly, my lord, on 1/7/2025, an SR has been lost by the police. And thereafter I was arrested. I have been granted bail. But the shop has been remained closed, my lord. My only grievance is that I have submitted a representation before the deputy commissioner. At any condition, I may be allowed to open the shop, my lord.
Shop or hotel?
Hotel. For my livelihood of and my family, my lord. Page 39 is my representation before that. This is my limited grievance. I will face the trial, my lord. I will face the trial before the trial court regarding my offense. And
we issue notice?
Man. He's running the shop, not the hotel, man. He's running the shop, but hotel now, my lord, hotel is not, man.
Hotel is closed.
Yes,
yes, my lord.
yes, ma'am.
Shop you are running.
Shop he's running.
My lord, I am divan.
Order is there against
Hotel,
shop,
my
ma'am.
lord.
What shop you are running?
Meat shop.
Meat shop. That is another aspect, my lord.
Well, he has annexed one of the orders, madam.
Earlier,
Page 35.
What else?
page 39, this
This
is
is
my
for bail.
No, 35 is, my lord, for, it's a writ petition, my lord, by the same petitioner, my lord.
Huh?
page 35.
35.
Earlier also they have attempted to close my shop, meat
Because-
shop.
Because
When I
of this
approached this
reason.
honorable court, they have stated that there is no apprehension that the authority will not close my shop, meat shop. But I
Because of
have,
selling beef, my lord, it
Yes.
was then done, but that or court directed, except beef, he may be allowed to sell, my lord, meat. I say,
But in terms with the Assam Cattle
Adult-
Preservation Act 2021,
my lord,
is it now permissible in any manner to sell beef in
My lord.
Assam? No.
my lord, some permission is, my lord, I have
don't-
seen, my lord, some,
Is it
the
permissible?
veterinary officer, my lord,
No, no, no. That
can
is not.
consider.
I don't think it is permissible.
my lord, power.
There appears to be a complete ban on that.
License provision is there, my lord.
That has been
They
said.
can only trade.
Trade, yes.
They cannot sell. Trade. You see what they can trade. They can
Not
trade
harm.
what? They can only trade, you see, notwithstanding anything in any other law for the time being enforced, the contrary, no person shall slaughter or cause to be slaughtered or offer or cause to be offered for slaughter any cattle, provided the killing of the by accident shall not be considered as a slaughter. Prohibition of slaughter without certificate from the year. Notwithstanding anything contained in any law for the time being in force, no person shall slaughter or cause to be slaughtered or offer or cause to be offered for slaughter any cattle unless he has obtained a certificate in writing issued by a veterinary officer Iman saying that the cattle is fit for slaughter. Now the certificate, which is also no certificate in there, shall be given that a cattle not being a cow is over 14 years of age. The cattle not below being a cow or a heifer or a year has become being permanently incapacitated
Yes.
or means either the cow, the cattle not being a cow, it cannot be a cow.
Oh. My lord, Rule 9 of Assam Cattle Preservation Rules 22, my lord. Rule 9 says, my lord, application and issue of beef shop.
With permission.
With permission, my lord.
For the purpose of section 8 of the act.
Yes, act is
Section
prohibition
8, let's see section 8.
Rule.
except at places permitted to do so.
Section 8 says prohibition on sale. No person shall be directly or indirectly sale or offer or expose for sale or buy beef or soya in any form except at places permitted to do so by
competent
the
authority.
competent authority, provided that no such permission shall be granted in such area or areas which is predominantly inhabited by Hindu, Sikhs, and non-between community within a radius of 5 kilometers of any temple, satra, or other religion in the belonging to Hindu religion or any other institution or area as may be prescribed by the competent authority. You may then have to have it inside the Brahmaputra river.
My lord.
Whatever he has, this particular proviso say, it becomes impossible to meet this proviso. Huh?
So whatever.
It's only in the midst of Brahmaputra river you may get this side or that side somewhere.
Even then, my lord, radius will not be 5 kilometer, probably, my lord, radius 5 kilometer.
And the 5 kilometers is as the crow flies. Anyways, now what do you want?
I pray for disposal of my representation, my lord.
Dismissal?
Represent.
Disposal?
Yes.
I don't
You-
allow.
yes. Notice my wish.
Let us pass an order, ask them why they are not
Yes.
permitting. Then I think you will
Yes.
get a better order. Because if I do it, they are going to reject and again you have to come back. Issue notice making it returnable on 29/10/2025. Mr. S. Dutta appears on behalf of the respondent number one. Mr. Miss Udas appears on behalf of the respondent number 2 and 3. Extra copies of the petition be served upon them during the course of the day. The petitioner herein is aggrieved by the action on the part of the respondent authorities in closing the hotel business of the petitioner in the name and style of MS Hotel Garib Niwaz. Run by the petitioner. The learned counsel appearing on behalf of the petitioner submits that the said hotel has been closed since 1/7/2022 on the basis of
25 months.
a case 22, na?
That has been closed from 1/7/2025.
25 or 22?
25. As per on the basis of FIR page 26. The manager has been arrested.
On 1/7/2000.
In the synopsis, it has been written.
Sir,
No, here it was closed when? Where is the closure order?
There is no closure order.
Then
they have entered my shop, hotel, my lord, and the manager was arrested and the hotel was
Miss-
kept under lock and key
Lord,
from 1/7/2020.
they have seized it.
my lord,
Yes, my lord, they have
my lord,
seized.
it is reflected in my lord, annexure 4 series, my lord, kiman page number ito?
When I
28,
paid
my lord.
Page 20.
In the bail order, my lord, it is clearly written, my lord, that the brief facts of the incident is that on 36/25 at around 11:30, an information was received about illegal cow slaughter and selling beef in a hotel named Hotel Khwaja Garib Niwas. They're located near Tini Mile Durga Mandir, Dolabari. Accordingly, charge was conducted in the hotel in presence of Circle Officer Sodor and Veterinary Officer Tezpur, Dr. Monila Bordalai. During the charge, suspected raw beef was found and seized. Accordingly, instead case such as cattle reservation in Malad, it pays Malad. So Malad beef was Malad seized, Malad raw beef was seized, and it was as per the Malad information was Malad given by one. I have received somewhere. I have
Page 26.
page 26 Malad FIR copy, your lordship.
We have a license.
My lord, for license of my hotel, my lord.
Hotel.
Hotel. For
Hotel, you have a license.
my lord, I have annex, my lord. That is annex in A series. It is Ponsat, my lord, local Ponsat.
Oh,
Page
that was for soft.
40.
No. You have a license for selling beef?
No, I have not.
No.
Is it your case that you are selling beef?
My lord, on that they have seized some amounts, but that has not been broke, my lord.
But the fact remains.
Yes, my
You
lord.
say you don't know.
I don't know, my lord, because they have.
Because your affidavit, the order which has been passed by Justice Kolita
Yes, my lord. They have seized,
clearly
my lord.
say that this hotel is run by your manager and you therefore don't know what he is selling.
Yes, my lord.
So therefore, if you are selling beef, then they cannot permit. But the
Yes.
only question is, can they attach the hotel without due procedure of law? Yes, madam.
My only
Hello?
grievance is that has
Can
been
you
kept in
keep
aware.
the hotel for closed without following the due procedure of law?
Malad, what procedure has been adopted, Malad, I'll have to, because charge operation was there, because FIR was filed, Malad, page 26, and basing on that, Malad, charge
No, there
operation
has
was
to
there.
be powers somewhere.
Malad, Cattle
You are,
Preservation Act,
you are doing under the immoval, the DC. What is the power of the DC for that? DCIA. Yes, if there is a violation out here, if there is without permission, person
Malad.
is selling beef out there,
Malad.
then what is the consequences here as per the Cattle Act?
Exactly, Malad, that is not here mentioned what will be the consequences, but
But without there
magistrate,
being an order,
Malad,
there has to be an order.
Yes.
You cannot keep a hotel closed unless you pass an order.
Malad,
Oh, tell.
11, Malad, 11 says, Malad, power to enter, inspect, charge and seizure and detains, Malad. There,
Everything, madam, you can do.
Malad,
But that has to be recorded with contemporaneous documents.
Malad.
Do you have it?
Malad Lordship may be pleased to, Malad, give me a chance to produce the same.
Definitely. This
Malad,
is the question which I am
Malad,
formulating and
Malad,
putting it
Malad,
to you.
Malad.
Now, the case of the petitioner herein is that on 1/7/2025, An inspection was carried out in the hotel premises of the petitioner. Pursuant thereto, pursuant thereto, on the basis of such inspection being carried out, it was allegedly alleged that the petitioner, in the petitioner's hotel, beef was being sold. Be that as it may, the learned counsel appearing on behalf of the petitioner submits that the respondent authorities under no circumstances can close down the petitioner's hotel unless they follow the due procedure. The learned counsel submits that there has been no orders even passed directing the petitioner to close the hotels, but the respondent authority are not permitting to open up the business of the petitioner's hotel. It is under such circumstances, representation have also been submitted to the deputy commissioner, district commissioner,
Yeah, district
which
commissioner.
has not been taken into account, for which the petition is filed. Ms. So-and-so, appearing on behalf of the respondent numbers 2 and 3, submits that she will obtain instructions and place it by way of affidavit as to whether the petitioner's hotel, whether there are orders passed for closing, for not permitting the petitioner to run the hotel business, and if so, under what authority? The said affidavit be filed by 22nd of October, next week. We filed on or before 22nd of October.
কিন্তু দোকানখন বন্ধ কৰিব পাৰিব নেকি?
Deeply applied.
Can it be, my lord, the next
Akita,
the next two?
what is it?
খুলিব ভাল। 14 তাৰিখে বন্ধ আছে না?
দুটা বজাত আৰু মেটা আছে। মোচন পাব। আৰু judgment আছে। আৰু কিবা আছে।
My lord, this can it be my lord, on the next my lord, it starts from 27, my lord, because again, my lord, there is a holiday for 3-4 days, my lord. 28th or 29th, my lord. So that I can positively file the affidavit, my lord.
Filed on 31st.
Deeply obliged.
Next date 31st, affidavit be filed by 27.
Deeply obliged.
In the meantime, it shall not be a bar on the part of the respondent authorities to permit the petitioner to run the hotel business
At any condition.
on the basis of the representations who submitted by petitioner dated
27/8/2025.
Deeply obliged.
You may
If they permit, my lord, up to the. Sorry.
Writ petition dismissed.
Deeply obliged, my lord.
I said out here, as regards that 427 thing, no. That cannot also be given, taking into account that because the lease cannot go contrary to Rule 21 as well as Rule 36(1) and Clause 27(1). That cannot be caught.
My lord.
And in fact, in view of the Manning rules, that's something impermissible at all. Be dismissed. Luckily, I was giving it in the last day before Puja, not imposing a cost.
And now, Lordship, we can proceed with the NIT, Lord. Now we
Yes,
can.
in time of the big.
Lordship. Oblige, my lord.
Your instruction.
Well, I have received instruction.
Rejected.
There was some mismatch, my lord. The
Just like that, show me your deed documents.
This is the tender itself, this has to be filled up, my lord. But exactly the one we have submitted, not there, my lord.
You submitted the bid as Deepak Chetri. And you submitted all your documents as
Joint
in
venture.
some JV.
Right.
How is it permissible?
But the power of attorney has been given in favor of Deepak Chetri, that is on that.
No, no, no. You submitted all the documents as the eligibility documents are
Joint venture.
of joint venture.
Right.
How is it permissible?
My lord, the tender was submitted through the power of attorney Deepak Chetri. my lord. This
No,
power
no,
of attorney is a
then-
part of the record.
No, it cannot be. Has to be by either the JV has to submit or by Deepak Chetri. Now, if you are only Deepak Chetri, you have to have your own credential. And if it is JV has the potential, but you submitted as Deepak Chetri.
My lord, the JB, my lord, is not an registered entity, my lord. So therefore,
JV is not, but JV is considered in legal parlance to be an entity. You see those judgments of the Supreme Court.
Lordship, that is there.
Starting with, what is the name? What?
So Lordship will see 105, the technical rejection, my lord, this one document, 105. The second bidder whose bid was accepted, it was a joint venture, my lord. in the name of the joint venture itself. 105.
Okay. You submitted as Deepak Chetri, but gave all the documents as JB.
JV.
Then
Because,
how will
because of the.
unless the terms of the tender categorically say that those things can also be taken into consideration.
Well, in fact, while scrutinizing the bids, well, not all the members' capacity of the joint venture are taken into consideration.
Cannot be.
And this is one of the clause. That is the clause.
Where?
But you will find the
Page
JV
number
part is at
46.
46, 45 starts.
45.
46.
46.
Yes. Demonstrating technical capacity and experience, the bidder shall over the past fee exceeding the fee they have received payment for construction execution of similar work or have undertaken construction by itself such that the sum is more than the estimated level. Provided the bidder has experience or has successfully completed so and in case of joint venture, the experience of any one member will be considered only. So then you have not submitted as a joint venture. You have submitted as a single entity.
Only the difference would be, my lord, that instead of mentioning, my lord, joint venture name, my lord, I have mentioned.
No. In case of a joint venture, you have to have an agreement that has to be also filed along with that. That
Yes,
is a
yes,
no.
it is there, my lord.
Did you submit that?
Yes, yes, these are submitted. These are submitted, that is submitted.
And you are submitting as a joint venture. Then why do your bid has been taken as you have submitted it as Deepak Chetri only? This is your bid document.
Page 94 is the, my lord, joint venture agreement, my lord.
So this you have to submit as is Deepak Chetri and RDS. You have not done that.
Look, that's what their objection, what it appears, that the tender was not in the name of the joint venture. But that has occasion because of the, it did not have the legal entity as such. So therefore, power of attorney was given.
No.
Deepak Chetri has given all the things.
Joint venture has to be given in a particular manner. There is 100% all tenders have a particular manner.
Because individual, each member's the capacity will be considered while calculating as per the annexure 5. Back to the.
Joint ventures are permissible, but you have to submit a joint venture. Okay.
This agreement is of the joint venture, that is along with the bids, page 100. But overall, the capacity of the partners of the joint venture will be taken into consideration while evaluating the bid.
Only one. Each member would be if it is a joint venture.
The Deepak
But you were relying upon the joint ventures total combined eligibility. Come to page 46. In case of joint venture, the experience of any one member would be considered. Last line.
Last line is there. That is even the Deepak Chetri, he qualifies as a lead partner. He is the lead partner, my lord. But then also, my lord, the first line, your lordship will.
But you submitted all the documents as a joint venture.
Of joint venture and the individual capacity of each of the partners have been given, and the Deepak Chetri as a lead partner, my lord, he qualifies the eligibility criteria.
Well, if you notice, they will only say, yeah, no stake. That's all I can do. You will notice, because this is the instruction. With these instructions, the jurisdiction of stay does not elect. Let them file it on their.
Well, the clauses, lordship will find, my lord, these are, my lord, the vague clauses, my lord, so far as the joint venture is concerned, my lord.
Huh?
It is, my lord, nowhere, my lord, it has been said that the joint venture has to, my lord, in his name or something, my lord. The joint venture
has to be in the name of joint
joint
venture
venture, my
only.
lord, the power of attorney of the, my lord,
No,
partners of
that
the joint
could be
venture has
joint
given.
venture. You can submit by one of the bidder on the basis of a power of attorney. There's no quarrel with that.
Right.
But as a joint venture, that is how you have to submit. But not as a joint venture that one person submits, although you have formed a joint venture, but only one person can be a bidder. No, that cannot be done. You should have submitted as a joint venture. Then all these things will have been taken.
In fact, that is our primary contention, man. That is our primary contention.
My lord, my instruction is, my lord, that it was submitted in the name of a joint venture, but the digital signature is of the, my lord, lead partner.
No. It was submitted as Deepak Chetri. This is what it is. This is the document.
The agreement has been annexed.
You see, refund, the settlement tender wise document and all these things, it has been submitted, bidder's name, Deepak Chetri. So, you should notice only.
Immediately after the vacation, my lord, the date may be fixed, my lord. I'll just verify, my lord, the exact, my lord, whether it was in the name of the joint venture or, my lord, the Deepak Chetri.
No, we'll put it on that aspect. There is instructions out there asking to file an affidavit. But I'll tell you, this is the reason why I'm not parking any. You notice making it returnable. And here the petitioner number 1 is the joint venture. You say he's not a legal entity, but he has filed the affidavit.
My lord, the 2 and 3 are given, my lord, 2 and 3 are.
Understood, but 1 is the main thing. You should have submitted in his name. He is not the bidder. Show me one document by which you show that you are how the bid document was submitted.
Well, this power of attorney I have shown, my lord, page.
No, not the power of attorney. Where is your bid?
The
bid will be there with you. Nothing is given. We have just enclosed this. And where is the statement that you have submitted as a joint venture? No. And you, wherever you feel like you are putting petitioner and petitioners
Paragraph,
in your petition.
paragraph 8, my lord.
Paragraph 9, not paragraph 8. Now you see petitioner states, you don't know which petition, that being eligible to participate in the state tender process and having vast experience in the field, the petitioner has already participated. Who? It's singular. Now kindly come down. The last, the petitioner since belong to the category of OBC. Now kindly see the petitioner here. You have used the word belonging to the OBC. Okay. Issue notice making it returnable on 10th of November 2025. Is the SR Burua accepts notice on behalf of the respondent of what? It's the SDAS with the standing council of the AITC.
2 and 3.
Accept notice on behalf of the respondent number 2 and 3. Those extra copies of the petition be served upon him during the course of the day. Upon them during the. As regards the respondent number 4, 5, and 6, steps be taken by way of speed post by tomorrow. In addition to that, the petitioner is given liberty to take steps on the respondent numbers 4, 5, and 6 by way of thusly take to the registry of the court and file an affidavit of service on before the next day. The petitioner herein who had participated, the petitioner herein are aggrieved by the rejection of the bid. The rejection of the technical bid of the petitioner. Rejection of the technical bid by the communication dated 19/9/2025. The reason, the learned senior counsel appearing on behalf of the petitioner submits is that there is no reasons assigned in the communication dated 19/9/2025 as to why the bid, technical bid, was cancelled, was rejected, except stating non-fulfillment of the NIT of the RFP criteria. Per contra, Mr. Estas, the learned counsellor representing the respondent number 2 and 3 submitted upon instructions that the petitioner number 2 submitted the bid in his own name, but for the purpose of experience and eligibility, laid emphasis upon the experience of the petitioner number 1. The learned counsel for the respondent number 2 and 3 further submits that a perusal of the letter comprising the technical bid would show that the bid was submitted in the name of the petitioner number 2 as proprietor, which is not the same as the entity whose credentials were relied upon for eligibility. And as such, there was mismatch in the name of the bidder and the documents relied upon.
May I interrupt one moment? But I have inquired, my lord, with regard to page 82, my lord, where the signature has to be made by the designated authority. But my friend is saying that also signed by the lead partner, Deepak Chetri. So it is at page 82. But I have just inquired, my lord, submits, my lord, this was also signed by the Deepak Chetri only, not the joint venture. So I think the otherwise also, my lord, the petition may not survive. So we may be permitted to withdraw, my lord.
Mr. PJ Saikar, the learned senior counsel. Court you heard Mr. P.J. Soike, the learned counsel appearing on behalf of the petitioner, a senior counsel assisted by Mr. Estas, appears for 1 and 3. আগতে এইখিনি কৰিব না। Notice the case of the petitioner is that are instructions to following that. The said instructions to place by Mr. Estas is dated 26/9/2025. Is kept on record and marked the letter X. Taking into account the said instructions, Mr. P.J. Soike, the learned senior counsel appearing on behalf of the petitioner submits that the petitioner that in view of the said instructions submits senior counsel appearing on behalf of the petitioner submits upon being instructed by Mr. So-and-so, the assisting counsel, that the petitioner would be well advised to withdraw the instant petition. Taking into account the above, the petition therefore stands closed on withdrawal.
Highly obliged.
Obliged. Item 21, fixed at 2 p.m.
Yes, what is your stand?
Lordship may kindly peruse paragraph 8 and 13, 13 and 17.
Huh?
Paragraph 8, 13 and 17.
Then
Lordship, paragraph 13,
13.
13, 171.
Paragraph 8,
Then 13, Lordship, page 171.
paragraph 8 and 13.
Here the Lordship, first of all, Lordship, the petitioner has participated against 2 items, mulching film and HDME vermifed. Lordship, in the mulching filling, Lordship, he didn't submit the BS certificate. In HDME, he was L5 and the private respondent number 4 was L6.
So his allegation is against the respondent number 4, not 5.
Yes, basically against 4, Lordship.
You have given some preferential treatment to whom?
Lordship, 4, he had submitted annual turnover report of only 2 years, which was our initial condition in the NIT, which was subsequently changed and corrigendum was issued. Thereafter, 5 years was given. And according to the bid committee, Lordship, that was a historical document and there was a minor deviation. So he was allowed some time to submit it and he submitted. Thereafter only the decision was taken.
Okay, that is L4.
Yes.
May I interrupt for a while, my lord?
Yes, one. And the allegation is against respondent number 6. 4 was L6. Response number 5.
Lot.
Mr. Goswami, what is the allegation against response number 5?
My lord, CPET test report. CPET test report. CPET is a laboratory. He's supposed to submit the test report of the CPET test laboratory of the particular item. But he has submitted CPET test reports issued in the name of some other parties, not in his name or not in his beneficiary name, or he has submitted CPET certificate of a specification which is not indented, which is not asked for. These are two basic allegations, my lord. And moreover, the CPET certificate is asked by the NIT for 12 months, 1 year validity. In affidavit, they said that validity is not mentioned in the tender. Therefore, 2017 CPET report should also given.
They deal with the CPS report. Number 6 submitted test report bearing numbers 12 data demand in which test values were found to give acceptable range for meter parameters of PMT 5. BIS certificate in this case is not a history. Therefore, BIS certificate cannot be accepted after expiry of the last date of the visa. Why is the BIS certificate not a historical document?
Lordship, may kindly take up the read petition. In the email submitted by the manufacturer for whom the petitioner submitted the bid, Lordship, there Lordship will see that is at page 110. Lordship, we so and so, Lordship, we do hereby undertake and confirm that our BIS certification application has been approved by BIS. As such, we have paid application fees, preliminary inspection search, and annual license fees dated so and so, transaction number so and so. Lordship, had they got
These
the
only came into existence subsequently.
subsequently,
When, what was the date of submission of the bid?
submission of the bid that was subsequently amended, it was 14/8/2025.
So as on that date, the BIS certificate was not in existence.
Not in existence.
Not existed, but we have applied.
No.
Not existed. Not
Where is
existed.
your BIS certificate?
My lord, I have not
Till now, not yet annexed.
You don't have a BIS certificate.
my lord.
You don't have a BIS certificate.
I have a BI certificate. I have deposited on 28, my lord. Hard copy. I have deposited to.
Now, where is the BIS certificate here?
It has not been annexed. No.
Not enclosed. How do we help you, Mr. Usami?
My lord, only one.
Your entire basis is that the BIS certificate is a historical document.
Yes.
And as such, the historical document they have been allowing others.
My lord, I have not enclosed because on 27th meeting, the department has accepted it that we have submitted the BIS certificate.
No, but then also you have to submit before this court.
My lord, that's wrong. That's wrong, my lord.
How can I help you? Okay.
But only one thing, my lord, so far historical document part is concerned. My lord, may kindly see.
No. This particular document otherwise shows otherwise.
My lord,
We'll have it after
most important part, my lord, only one thing.
Mr. Goswami, you have not enclosed the BIS certificate. That is your main document. In respect to the Munson, claims and all, it is the BIS certificate. You say that it is the historical document which should have it. They contend that the reports or the annual turnovers of these periods are there available as per the income tax reports.
Yes.
So these are historical. There is no quarrel that they are historical.
My lord, this is not historical, my lord. There is a advisory of the government, my lord. Kindly see it, my lord.
What?
The turnover is not historical. What they termed as historical is a wrong submission, my lord. Kindly see, my lord. Kindly see this one.
But that is in the case of response number 4.
4.
We are not concerned with response number 4. He is L6.
Yes, Lord. Kindly see. 2012-2024. The
In case of minor and non-conforming, the bid evaluation shall.
Roman 2, my lord.
Respect to those non-conforming which are historical in nature. For example, missing fields.
Attachment of eligibility in a submitted document.
Non-substantive changes in qualification. Where are you referring to? The shortfall information area should be sought only in case of historical ability existed at the time of the tender opening and which had not undergone change since then. These should be called only on the basis of recommendation of the tender. Example, audited statement of account.
My lord, clause 6 specifically said, last page, clause 6.
Example, if a bidder has
The-
not submitted
the
the
pro-
turnover certificate, then the same cannot be sought under 23(1) and this cannot be the as minor deficiency. However, if the bidder has submitted turnover but failed to submit a completed statement of account, then the same can be sought. But that is only in respect to response number 4.
4, my lord.
So we are not concerned, he has not got it.
No, Lordship may kindly take our affidavit at page 186. We have given the financial competitive statement, Lordship.
Page
186, Lordship.
Mhm.
Serial number 2 and 6. 2 is emulsing film and 6 is the SGME Burmese bag.
Response number 4, what is the name?
Respondent number 4 name is
Page, no? Page.
Daisy Industries, Lordship. Daisy Industries.
Daisy is not here in Mulsing.
Emulsing,
One.
it didn't participate only in serial number 6. Yes, Lordship.
It's the pipe they had submitted,
Yes,
but they are.
L6.
You have given JK Commercial
Yes, Lordship.
Good year, yes.
and JK Commercial is a party here.
Yes, Lordship.
And the other one, you have.
The one is,
Laser Lane.
yes, Lordship.
Laser Lane is no problem.
No.
Okay. This court have duly taken note of the affidavit in opposition filed by the respondents, as well as the additional affidavit filed by the petitioner.
120.
This court, however, finds it relevant to take note of that the petitioner have not enclosed the BIS certificate, which the petitioner claims to be a
109.
historical document. The same be brought on record by filing an affidavit, additional affidavit. This is matter on 24th of October 2025.
My lord, BIS certificate, we have enclosed, my lord.
Where?
At page 119, my lord. Kindly see page
You don't
118.
know your brief. I've been asking you that only. You are not prepared, then don't do the matter.
Page 118, my lord.
Lordship, only the attachment to the email, Lordship.
Page 118.
Yes.
It's a letter, August.
So where is your BS certificate?
Next page, my lord, kindly see 119.
How do I read it?
Well, my come to page 120, my lord.
Ah.
Serial number 12. I am a licensee under the BIS authority. Serial number 12, my lord.
Ah.
Imperio Polymers. This is my manufacturer, my lord.
Understood, but when it was given, where is your certificate? How do I read it? Tell me. You can read it, read it.
My lord.
No, Mr. Gustami, you are spoiling the time of this court, but anyway, I give you an opportunity. Read page 119. What is given out here in that? What is the contents of this small one Imperio, that letter?
121.
Read it.
My lord, kindly.
Read it. WhatsApp image 2025-828-8-2020.
This I'm
This
sorry.
is the WhatsApp image. How do I read it?
My lord, it was sent like this much. Your order will be given.
Production list, motion item 1.
My lord, has it been dismissed, my lord? I have not heard the order, my lord. I have not heard the, my lord. Matter is still alive, my lord, I think. Matter is still alive, I think.
Yes, it is still alive. I've asked you to file a reply if you want.
Yes,
The affidavit in opposition, and also file an affidavit bringing on record the BIS. I fixed it on 24. 24. Huh? 24.
Briefly, okay.
Yes, Mr. Hawk, you and Mr. Jial Fasa.
My lord.
Bench for
Material.
one person is always there. Jial Fasa.
Well, here, matter
Mr.
participant.
Hawk is the standing count.
Well, here, well,
What has happened here?
Limits of the petitioner, my lord, the site visit certificate of the petitioner, my lord, that was not countersigned by the executive engineer, my lord.
Huh?
The site visit certificate, my lord, site visit certificate.
Ah, they have not been given.
No, no, my lord, not countersigned.
When is the last date?
My lord, last date is over, my lord. In fact, my lord, he had already submitted the certificate without countersigning the executive engineer, my lord. Now, here, my lord,
So you have submitted this?
yes, my lord, kindly come to page, my lord, 169A, my lord. This is the, my lord, they have rejection, my lord. How they have rejected, my lord. 169A, my lord.
They have rejected your bid.
My lord.
When?
My lord.
6-9.
Yes, my lord. This is the letter, my lord, by which, my lord, that they had rejected my countersigning the site visit certificate, my lord. In fact, my lord, petitioner had visited the site, my lord, along with some photographers also attached, my lord. Although, my lord, as per clause 7, my lord, those are not necessary, my lord. And there is no any SOP, my lord.
What was the last date?
My lord, last date was 6th, my lord.
Huh?
Last date of submission of the bid was 6th, my lord. 6th of my lord,
6-9.
Yes, ma'am.
And you approached the executive engineer after getting this order on 5-9 on 5-9.
Yes, my lord.
And then?
Now, on the same day, my lord, petitioner visited the site and he had annexed some photograph and submitted the.
So this was received by the executive engineer?
My lord.
Along with the photograph?
Yes, my lord.
But
On the
they
next
did
day,
not.
my lord, next day, my lord, it was, my lord.
Huh?
On 6-9, my lord, it was again rejected, my lord.
Not given. Fellow, this is a case.
My lord.
One thing we can do. This is a very important issue. I have fixed another matter as to why this court should not impose, make it a constitutional law. Good. You want to fight it out properly? Because in the other case, the council wants to withdraw. I have not allowed the withdrawal of the writ. You will fight this case properly?
My lord, I will.
Ah, good. Please stay the tender process. This cannot happen like this. You have taken this site visit certificate. You cannot reject it on that basis. If he has submitted for whatever vested reasons these executive engineers are doing it, this cannot happen.
My lord will come to 169.
No, nothing doing. When a person has given the site visit certificate, it is your duty to give it. Why are you not giving it?
It is just like an undertaking, my lord. It is just like an undertaking.
My lord, already he has been given a liberty, my lord, in the last paragraph, my lord, of 169.
Liberty, against that liberty, he went out there and he submitted on 6-9 at 11:05 AM. See, this is the signature. All these things were received. The last time to submit the amount was at what time? 1 o'clock or
Yes.
2 o'clock?
My lord, that was 2 o'clock, my lord.
2 o'clock. Then you don't give it. What to do? We stay this process. I think this is another thing which can happen. We stay this, all these notice inviting tenders, do whatever you think. Don't need. Issue notice. Every day I am passing 3-4 matters, orders, giving direction for site visit, saying that don't insist to issue this. issue notice making it returnable on 10th of November, no, 3rd of November, 2025. Mr. Ardhor accepts notice on behalf of the respondent numbers 1, 2, and 3. The petitioner herein is aggrieved by the actions on the part of the respondent authority in not issuing the site visit certificate. And more particularly, the respondent number 3. And resultantly, it has been rejected. Your bid.
Yes, madam. First one, madam, it was rejected, madam.
Wait, no. Has the bid been rejected?
No, madam, not yet, madam. They had not yet, madam, finalized the bid, madam.
Where is the last date for submission?
It was 6th, madam.
Huh?
6th of November, madam.
6th of November is
Yes.
the last date.
My lord, page 35, madam. Tender time schedule, madam, but it has not yet been finalized, madam.
Sixth of September.
6th of September, sorry, madam.
Why are you saying 6th November?
No, sorry, madam, September, madam.
Then what happened on opening? It has been rejected.
Not yet rejected, madam. The petitioner has not received any.
My lord, 169A, my lord. I'm just 169A. 169A.
Yes.
My lord, he has been in the last para. You are therefore hereby instructed to submit the complete set of required documents and photograph covering all concerned sites without exception, along with other supporting evidence at earliest. Without the same, your request cannot be processed further. So my lord, on 6/9/25 though, just last night he was given a liberty to file.
He has duly submitted all these photographs. What with geotech? What else is required?
Then my lord, what I suggest is, my lord is already in a similar situation.
You accept his
17.
No, on the earlier order pass.
My lord, 173.
That order is wrong. Another order yesterday also I passed. I'm more fine-tuned. Because every day I'm passing 3-4 orders. So every time it becomes better.
It's refining.
Okay. Yesterday I passed 1 order. Here you accept, you cannot reject his bid on the basis of site verification certificate not being come. The site verification in view of the fact that he has, I'm disposing it. In view of the fact that he has submitted this document on 5/9 to the executive engineer along with the signatures at page 167 and 168, the same shall be construed as the site verification certificate, site visit certificate of the petitioner, and the respondent shall not reject his technical bid on the basis there. And remaining, whatever you do, reject for whatever other reasons you do.
No, my lord, even I said this fair enough. My lord, he has given photographs. That is there. So my lord, even I even my lord understand this one. It's a geotech.
When was the tender issued?
My lord.
When was the tender issued?
13/8, my lord.
Huh?
13/8/2025.
Page 35 is the my lord timeline, my lord.
Mr. Counsel, I'll dismiss your petition. See the timing of the photograph. Date of the photograph.
Well,
Page 169. 169.
9/5.
How? Why did you take this photograph on 9/5 when the tender was issued on 13/8? Tender publishing date is on 13/8 and you have visited the site on so and so. Mr. Hawk,
yes.
I am dismissing it with a cost of 1
No,
lakh now.
that,
No. This is the cost of 1 lakh. Upon, and you have certified it. Who is that? Who
Yes,
has
madam,
certified it?
I have certified.
You have
Yes,
certified.
madam.
So 75,000 upon you and 1 lakh upon the petitioner. Cost for falsifying, for giving
No, my lord.
false statement. No, absolutely.
Yes,
These are-
my lord, I have also noticed, my lord, but that photograph, my lord, that photograph was taken, my lord. I don't know whether there is any fault on the date of setting date in his camera or not. I don't know, my lord.
No, Mr. Hawk,
My lord.
I'm telling you, the time when you are taking a photograph
My lord.
and you are submitting before this court that
lord.
after the order passed by the learned coordinate bench on 5/9,
My lord.
you submitted this
Yes,
along with the
yes.
photographs.
Yes, my lord.
The photographs has to be either at least from the date on which the tender document was issued. The tender document was issued on 13/8/2025.
My lord.
And under such circumstances, these photographs cannot be taken as on 9/5/2025.
Yes, my 995, they should
This
not
is
be.
dated
Yes,
9/5.
yes, my lord.
Then,
I've also noticed now.
so 1 lakh upon your client and 75,000 upon the person who has certified it. You 75 upon you. Like,
My lord,
dismissed with cost of 1
my
lakh.
lord, madam, taken up after immediately.
No. This is a
My lord,
cost. No,
My lord, kindly.
Mr. Hogg, this is a cost which has to be gone and it should be shown as a deterrent. That how do you certify? You could not have certified this document. You knew it. You have
My lord.
submitted before this court a document of 5/9 saying that you have visited pursuant to this order.
Certificate.
It could not have been possible.
My lord, just wait, my lord. It is here, person. Asa.
My lord will come to page 167. It is very interesting, my lord. 167.
Oh, 950.
Prior to publication of standard, he knows about everything, my lord. 167.
167.
That pursuant to clause 7.1, he states here that he has visited on 5/9/25. Whereas his photograph is of 9/5.
My lord, whatever, my lord, sometimes, my lord, date and day, my lord, it alters, my lord, the settings, my lord.
Show me earlier, it has been mentioned. Show me
My
another
lord,
one.
yeah, I have all the photographs, my lord, in mobile, my lord, I have just this. Sometimes whatever, my lord, in some calendar, my lord, setting, my lord, date shows prior and month shows later, my lord. There may be some, my lord, but I can have this photograph, my lord, for forensic, my lord. Because, my lord, after passing the order, my lord, earlier order, my lord, of this court, my lord, I had instructed the petitioner to visit the site, my lord. And immediately he had visited the site, some such site, my lord. And print the photograph and he had sent me that, my lord.
And then you submitted it.
Yes, my lord.
At what time?
My lord, at around 4 or 5 p.m., my lord.
Are you sure?
Not sure, my lord, but he had submitted, my lord.
No.
On the
You
same day.
submitted on 5/9 or 6/9.
No, no, 5/9.
This is dated 5/9.
5/9.
At what time?
Time I cannot say, my lord, but at the same date, my lord, he has submitted, my lord.
No, the office is not open till night.
Well, let us see. PWD office sometimes works, my lord, lately also.
Till what time?
I don't know, my lord, but
It is on affidavit.
my lord, here, my lord, they have received on the 5/9, my lord.
No, they have received it on 6/9 at 11:05.
No, my lord.
Yes.
166 page.
They have received it of 6-9 my lord. But in the top my lord, it is 5-9 my lord.
You have written as 5-9. They have received on 6-9.
6-9 my lord.
Okay.
My lord.
So therefore, I'm asking you, when did you submit?
My lord, can I have some time my lord? I will.
No, after vacation. Okay.
And
Because you
so
see,
far
and how far is this place from that place?
my lord,
Nalbari Territorial Division and this particular place is where? The site
Right.
is where?
within that within the Nalbari district only.
Nalbari district from one place to another takes half an hour minimum.
My lord.
Some places,
Right.
where is it?
My lord, petitioner is he is originally independent of Nalbari town itself my lord.
Huh?
So my lord, he is also a resident of the Nalbari town my lord. So my lord, he is and we have as told contractor my lord, he has the knowledge of.
The photo was clicked at 4:53. In the evening, 4:53, the photograph.
No, there is one at the 1707, which means
Yes.
at 5 o'clock.
5 o'clock.
Yes. Yeah. এই করেছি মানে এই করেছি
Not bad, not satisfied.
বারো 354 মাইল 344 it is 1544 means 344 মাইল
I know that.
he said
It is 1707.
Wait.
one is well 1544
Kindly come to page 168, top one.
Yes. But it takes some time because here my lord, I have got 4 photograph my lord. One at my lord 1544 my lord. Another 17-7. And 1653.
No, this, I'm not satisfied that. Unless you say these photographs are, you have to give some evidence. No, satisfied. These has a timing of 9/5/2025.
My lord.
Can't help you.
My lord, the last date was 6/9, my lord. Last date was 6/9, my lord.
Understood 6/9, but it is 9/5. How on 9/5?
9/5, that was I am submitting my lord.
I understand what you are submitting. You are submitting that the date and month sometimes interchange.
Yes, my lord. Yes, my lord.
And therefore it has become appeared as 9/5.
Yes, madam.
But then that is wrong. You can't have it. That's good. Photographs cannot be taken into consideration. You have to be careful. When you are submitting the tender
My lord.
and when you are approaching the court, you have to be more careful.
Yes, madam.
It is undead.
Otherwise, my lord, the photograph, my lord, it definitely was taken on my lord 5/9, my lord.
The order of
After-
at page 169A does not call for any interference.
Moreover, my lord, site visit certificate, my lord, it is just an undertaking, my lord.
Understood. But you see, undertaking or not undertaking is another thing. But I can't help you with this 9/5. I can't help you. You have to give up this time. Next time, be more careful. Heard Mr. Ashok, the learned counsel appearing on behalf of the petitioner, as well as Mr. Hardhor, the learned counsel who appears on behalf of the PWD. The petitioner is aggrieved by the action on the part of the respondent authorities in not issuing the site verification certificate, site visit certificate, in spite of the fact that the petitioner had approached the respondent number 3 by the communication dated 5/9/2025, along with photographic evidence containing geotag locations was- This would duly have perused the materials on record, more particularly in lecture F. And from a perusal of the said document, it is seen that the request by the petitioner for the site visit certificate was received by the office of the respondent number 3 on 6/9/2025 at 11:05 AM. Be that as it may, this court duly takes note of the photographs which have been enclosed to certify that the petitioner had in fact visited the site. This court duly takes a perusal of those photographs, which are at page 168 and 169 of the petition. It is seen that the time mentioned is 9/5/2025. This court inquired with the learned counsel appearing on behalf of the petitioner as to what is the date on which the notice inviting tender was published. The learned counsel submitted that it was published on 13/8/2025. The learned counsel submit that the date and the month must have been wrongly mentioned in those photographs. Inasmuch as per his instructions, the photographs were taken on 5/9/2025 at the times mentioned in the photographs. So submitted as it may, taking into account that the photographs were taken even prior to the notice inviting tender being published, this court does not find the respondent authorities any illegality on the part of the respondent authority in not accepting those photographs for the issuance of the site visit certificate. So consequently, this court doesn't find any merit in the instance petition, for which the petition stands dismissed. Yes, Mr. Chaudhary.
For rejection of technical bill,
Other side.
Yes. At page 49, this is the technical evaluation report.
You are there.
To prison. IGP, prison.
Yes. Home and Inspector General of Prisons. No copy has been served.
Yes.
Your technical bid has been rejected.
Yes.
Why?
The lordship will find at page 50, relevant. Serial number 8, MS Bhavani.
Annual turnover 5 crores is submitted, for which MSME certificate is required.
That certificate was not.
Registration is not submitted. Yes.
Yeah, initially, 3 years, last 3 years, average of 12 crore, the turnover, that was the condition. Subsequently, it was changed, and by a corrigendum. Your lordship will find it is 43 annex 3, the corrigendum. 43 minutes. In supersession of earlier corrigendum, dated 21/8/25, please read the minimum average annual turnover last 3 years, as mentioned in clause 4A of additional terms and conditions in connection with the tender, so and so. Zone 5 jails of Assam during the financial year 25/26, dated 6/8/25, as 5 crore. In respect of micro, small, and medium enterprises. In case of others, it will remain the same as.
Anybody call Mr. K. Gogoi?
Yes, madam.
Mr. K. Gogoi, because I dealt with this matter.
Yes, madam.
And this led to that passing of that order,
Yes.
by which they
10 crore.
came down and made that original.
Yes, 10 crore, Malad, it was made.
10
Yes.
crore they had, then they made it
Yes.
5 crore.
I have got the order.
Yes.
That order, your lordship passed that order.
Yes, then It's 5 crores now.
5 crore.
Five
But then,
Matlab that MSME certificate that was not submitted, matlab, along with the technical bid, matlab.
then how do you get it?
Matlab, after in the corrigendum, matlab, that is not mentioned in the that certificate will be required, matlab. In the tender bid document, matlab, there is no instruction, matlab.
No, if you are claiming benefit under the MSME, you have
There
to
has to
submit
be-
their MSc certificate.
As per your lordship direction, Malat, it was 6/9, extended up to 6/9 months.
Ah, okay.
Yes, Malat, no case, Malat, at all, Malat.
Matlab, only that certificate, matlab, 5 crore turnover that has been submitted, matlab.
Extension notice is page 42.
5 crore turnover is there, but for the purpose of being an MSc, you have to certificate, give that certificate, this one.
Matlab, in the, your lordship may kindly see page 16, matlab, there.
Huh?
Page 16 of the tender notice.
Yes.
Here, matlab, the clause 8, matlab, Roman 8, the requirement of a certificate, matlab, valid
Right.
registration certificate issued by the district industry.
It comes clause 4. 2 another one here.
Matlab, here is mentioned regarding the requirement of certificate, matlab, but MSME certificate that has not been mentioned in the bid document, matlab. Matlab, as per Procurement Act and rules, matlab, this should be reflected in the bid document, matlab, for compliance. In the corrigendum itself, matlab, it should have been mentioned, matlab.
If you are claiming benefit under the MSME, you have to give the certificate.
It is correct, matlab.
Not given.
Malat, by now, probably, Malat, already, process has already been completed because an urgent matter, Malat, because that.
No.
went to jail.
A2 doesn't arise then. The question is whether should I issue notice that is the
Malat, probably, Malat, already he missed the bus, Malat.
A is not considered. Should I dismiss it right away? You are opposing and notice, I think.
No,
Not the
I,
interim order.
Malat, interim, Malat, doesn't.
No, you are
already.
opposing a notice, not
Malat.
even an interim order doesn't arise. You
Malat,
also
Malat,
know it.
correct, Malat, because already your lordship has already, Malat, it has come under your lordship's scrutiny,
I know
Malat.
that.
Lordship has already scrutinized
If you want to claim here, nothing.
pros and cons of the this tender, Malat.
Earlier it was 10 crores.
Yes. More than
12 crores.
Huh?
12
No, 11.
11 crores.
11.
Your lordship then.
11 crores.
yes.
Then they made it 10.
10.
Then I said 10 can't happen because now they have made it. Then I say that the average can be 5 crores at best. So therefore they made the 5.
There should not be any Malat ceiling on Malat.
Otherwise, these additional terms here it says, see, 11 crores is here, na? 11 crores. Yes.
In the
It has
corrigendum.
been amended.
12 crore,
Clause
matlab, in the
4.
corrigendum.
Clause 4, additional terms and conditions. Page 36. Hello. Issue notice. Notice? No notice.
Malat, yes,
Wait a minute.
because
You go ahead.
36
You go ahead with that.
Yes,
Malat.
Not, I won't even make it subject to outcome.
Malat, because already your lordship has already seen all the
Issue
tender
notice
conditions. Malat.
making it returnable on 17th of November 2025. No. Ms. Swenso accepts notice on behalf of the respondent numbers 1 and 2.
1 and 2.
As regards the respondent number 3, 4, and 5, the petitioner is directed to take steps by way of speed post by tomorrow. Date to date. the petitioner herein is aggrieved by the rejection of the petitioner's technical bid in the technical evaluation report dated 29/2025. The reason for doing so is that the petitioner, for the benefit of claiming the petitioner, doing so is that in terms with the additional terms and conditions of the contract of the tender document, and more particularly clause 4 dated 6/8/2025, the tenderers the tenderers are required to submit the minimum and average annual turnover over the last 3 years, and the minimum average annual turnover of the bidder for the last 3 years should not be below 11 crores. However, taking into account clause 4.12 of the notice inviting tender, a corrigendum was issued pursuant to a proceedings being WPC number. What is the number?
The 4666020.
So and so. An additional corrigendum was issued whereby dated 26/8/2025 that in respect to micro, small and medium enterprises, the annual the minimum average annual turnover for the last 3 years, as mentioned in clause 4 of the additional terms and conditions, is 5 crores in respect to micro, small and medium enterprises. So the petitioner herein, though had participated in the said tender process, but did not place any evidence that the petitioner was an MSE enterprise. It is under such circumstances that petitioner's technical bid was rejected. So considering the above, this court is of the opinion that this is not a fit case for issuance of any interim directions. So, the respondents are directed to bring on record their stand by filing the affidavit on order.
If financial bridge is open, in the meantime,
the respondents are at liberty, taking into account that these are the contract pertains to supply of dietary articles, and there is an urgent need. The respondents are directed to go ahead with the settlement of the said tender.
Deeply obliged, well.
It may not be last portion of the order.
Stay is not rejected.
Because this will otherwise this may be remain because otherwise it will be confusion to the rest.
No, there has to be.
Maybe
Department would have waited since last portion of the order may be there.
No, last portion has to be there.
there.
Because last time also I have vacated one case.
Yes, two matters
Because
were there.
it's, what happens, any order they stop it and then there's a huge problem. What happens, it is not your problem. You are not going to get the benefit. There are people who are otherwise supplying.
Yes, I do.
They take the benefit.
They will be continuing.
And one of the cases where the interim order was passed, I did not extend.
That did not,
I
yes,
vacated
did not extend it.
There is a big problem which is going on.
Finally, Lordship heard the matter from Kohima Bench, my lord.
There.
Yes, ma'am. So the last portion may be, my lord, retained, my lord, last portion. Deeply obliged.
That may be fixed.
Yes, Mr. Sheikh.
My lord, here in this case, for 10 minutes, my lord, I have lost the case for 10 minutes because last time was 10:30. But I draw this deposit, my lord, at 10:40. So ultimately, it is not annexed with the tender notice. Now your lordship will consider that my tender has gone.
your lordship will consider
And
another.
then you are illegible.
Yes, my lord. Another aspect is this, my lord. That respondent number 7 is to submit bank security by fixed deposit. If fixed deposit is not submitted.
Mr. I'm not going to look into that.
My lord.
At the instance of a bidder
My lord.
who has not submitted. And Mr. Sheikh, I will advise you, though it is not a part of the court to say so. You have made a wrong
No, my lord,
statement.
your lordship,
Mr. Sheikh, you have made.
only your lordship
No,
will consider.
Mr. Sheikh.
That record was called for by
No,
your
no,
lordship.
everything is understood. But the fact remains that you have made a wrong statement before this court. Don't you think you being a senior counsel out there, don't you think that this is not a quick case where the petitioner should be given indulgence? Because he gave wrong instructions to you that he had submitted the fixed deposit. He should not have given that. If it was only found out that at 140 he got it and he could not have submitted that document.
That's chairman.
So I don't think that I should, with that document being brought on record, thereafter I don't think that this is the case by which notice can be anything more can be done. Till the document was there, available, and if it was that document was very much submitted along with the bid document, I would have definitely passed it. There's no quarrel with that.
Well,
You have also
not
seen,
on that,
Mr.
my
Sheikh,
lord.
Mr. Sheikh, I have taken this matter on day-to-day basis.
Yes,
So that if you,
that is there.
normally you won't find that in such quick successions, the matter is being taken up. The matter has been taken up on all these days. Every day I'm taking up this matter. But I don't think now, I think because of the fact that this information is correct, petitioner should, I think, have a go, leave it as
Well, that is there, my lord. My only point is this, my lord. When your lordship called for the records, they did not submit the bank deposit as required by tender notice. They did not. And
Now, do
another
you want
thing,
a judgment?
another thing, your
No,
lordship.
Mr. Sheikh, do you want a judgment? I can pass the judgment. I gave you the opportunity. Now you want the judgment? I can immediately pass it on. But then I'll impose cost upon you for making false statement on oath. Because here there is a categorical statement made by you that you have submitted the bank deposit, which could not have been possible taking into account that the last time for depositing is at 1 p.m. You got that document at 1:40. Why should this court spend unnecessary time on a matter where the bidder out there has not come up before this court with clean hands? I'm exercising equitable jurisdiction.
What, my lord, I'm
But
listening to
Mr.
you.
M.A. the learned counsel is appealing on behalf of the petition. The learned counsel submits that pursuant to the order passed by this court on 22/9/2025, he had obtained instructions from his client that the petitioner could not submit the fixed deposit in time at the time fixed deposit for the fixed deposit for the earnest money. What is
Earnest
that?
money, earnest money.
Earnest money.
Earnest money.
Earnest money along with the bid documents. And therefore he submits that the petitioner would not like to further proceed with the instant petition. Accordingly, the petition stands closed.
Problem. Item 9.
Yes, what is this?
As per the earlier order, my lord, extra copies have been served to the respondent, my lord.
Lordship, reference has been initiated, Lordship, the voter matter, Lordship.
Yes.
The voter.
Reference is there.
Yes, Lordship, initiated, Lordship. Reference has been initiated, Lordship.
What is the number, reference number?
Lordship, this is memo number, Lordship. It was written to the concerned foreigners tribunal, Lordship. Memo number BKRJ B KRJ WPC. So and so.
Where?
At the top, Lordship.
Heard, Mr. Islam, the learned counsel appearing on behalf of the petitioner, Mr.
G. Sharma,
appears on behalf of the FD.
respondent number 3, 4, and 6, Lordship.
3, 4, and 6, and Ms. P. Bulwa appears on behalf of the Election Commission of India. The petitioner hearing is aggrieved by the letter D attached to his name in the voters list of
2011 onwards.
29 number Pukradar ST
Yes.
since 2011. This court passed a detailed order on 17/9/2025, seeking instructions as to why the petitioner name continues to remain in the voters list and what step in pursuance thereto, an instruction have been placed before this court dated 29/5/2025, issued by the Senior Superintendent of Police B. Pokraja, wherein it has been mentioned that a reference has already been forwarded to the Foreigners Tribunal Pokraja against the petitioner to determine whether he has entered into India from Bangladesh on or after 25/3/1971 and since then residing illegally in India or not. The said instruction is kept on record and marked the letter X, taking into account that the reference has already been made to the Foreigners Tribunal Pokraja, the respondent, the relief which have been sought for by the petitioner in the instant proceedings cannot be granted. The petitioner would be well advised to approach the Foreigners Tribunal Pokraja and participate in said proceedings. Accordingly, the instant petition stands closed on the basis of the above mentioned instructions.
Supplementary item 20.
May it please your lordship. Last occasion, lordship, they sought for some time to file an affidavit. We have received their copy yesterday, lordship.
They filed that?
They filed it.
That is why I wanted that fix this matter only for that.
For that, lordship.
Lordship.
Lordship, I do it.
Now every pleading is complete.
Pleading is complete, lordship.
There's an urgency or no urgency?
Lordship, there's some urgency, lordship. Has been hanging on since.
The pleadings amongst the parties are complete. Mr. H. Pitala, the learned counsel appearing on behalf of the petitioner, expresses urgency. This matter on 13th of November 2025, on which date an attempt shall be made to dispose of the petition.
TP of lordship.
You give your names, huh? All of you give your names, they'll put it.
For orders, item 10.
Lordship. Lordship, as per instruction,
you got the 5 lakhs?
Oh, no, Lordship, 4,71,000.
That is what you will get. 30,000 will be deducted. 194. These are construction, na?
Yes, ma'am.
Works contract.
Good, good.
So they will be deducting the tax.
So ultimately, 4,71,800.
So you have got that amount.
Lordship, the list is the payment that has been made in the PNRD department and the petitioner number is at serial number 115.
115.
Lordship, that flag mark. And
This is the 5 lakhs.
Yes, Lordship.
He has got it.
Yes, he has got it.
So nothing remains now.
Order was for 27
Remaining-
lakh 60,000 Lord.
Huh?
Order was for payment 27 lakh 60,000. Out of that, now they have paid amount of 4 lakh 71,800.
5 lakhs, Lordship, and that.
Where is the direction? Show me.
Direction what is the page Lordship 46.
The respondent are directed to pay the petitioner the outstanding amount of 27 within a period of 3 months.
Lordship.
You have paid only 5 lakhs.
Yes, yes, my lord.
And what about the amount remaining?
The Lordship, there is a dearth of fund under the SOPT. So as and when the budget allocations are made, 10% to each and every department has been given, and from that amount, Lordship, all has been paid. Lordship will see in the list, average 5 lakhs to everyone is given.
That is not, that was not the order and order part of the requisition. Lordship, currently should have paid
That
30.
we cannot accept. We're taking into account unless you seek a review of this order. Problem
Lordship,
arises there only.
that
You see, my hands are tight. I can't help you. You seek a review, get an order, cancellation of that order. But there's a direction for you to pay. You have to pay within 3 months. If you don't pay, give us, means you cannot say that we have no money.
no, but we intend to make the payment, but
When?
as and when the.
Okay,
the-
it has been submitted by Mr. B. Chaudhary that an amount of rupees 5 lakhs have already been paid, to which the counsel for the petitioner submits that after necessary deduction of tax, the petitioner has received an amount of 4 lakh 70,000 and odd
71,800.
800. So, taking into account the above, this court inquired with Mr. B. Chaudhary, the learned counsel appearing on behalf of the BTC as to when the remaining amount as directed by this court shall be paid. The learned counsel appearing on behalf of the respondent submitted that there is a dearth of funds to submit. Be that as it may, taking into account that there is a specific direction to make the payment within a period of 3 months. The respondents are directed to provide a file a detailed affidavit as to how the said amount would be paid. To establish this matter again on 22nd of October 2025. The affidavit be filed on or before 17th of October
Lordship,
2025.
can it be in the first week of November, Lordship?
No.
No, because Lordship, today the countings are going on, there will change of government or whatever, Lordship, some time will be required, that's what
Okay, 29. Affidavit filed on the 31st ko দিব, affidavit filed by 27. On 10.
Yes, my lord, for instruction.
You have complied with, na? This one is item 12.
11.
11, okay. Have you complied?
But we have submitted the fund demand to finance department. We have received the proposal number also. So as per our instruction, I don't know when the finance gives its
That
sanction.
Finance cannot have like this type of, yeah. Because are you saying now that the finance is interfering with the cause of justice? If you say so, put it on affidavit, we take it up against which officer? Don't worry. We will take, because this plea, which is all the other departments are taking, putting the entire burden upon the finance cannot work.
No.
When there is a direction passed by this court, it has to be honored by that department. Because we are not concerned whether it is the PHE department, the water resource department, PWD department, whichever it is. It is overall, it is under the state of Assam, and the state of Assam has to speak in one voice. Or are you saying the state of Assam, all the departments will speak in different voices? Cannot happen. We are not bothered that you are going to take up with the finance and the finance doesn't pay. Can't help it.
It was submitted in June of this month.
I'm not concerned. You give a
Affidavit.
should I record it? The finance is not doing it, so give the name of the officer who is not doing it. or we make the finance secretary a party, because we consider, we'll say that the finance is interfering with the course of justice. Then initiate send the matter to the division bench, because interfering with the course of justice will come under section 15, isn't it?
Small amount.
15 criminal contempt. Division bench will take it up. And it goes outside my hand.
We'll file an affidavit, my lord.
Mr. Ibotago, appearing on behalf of the PHE department, submits that the PHE department had already given the financial sanction. However, the concurrence with of the finance department is awaited. It is the opinion of this court that that if there are specific directions passed by this court for making payment, the finance department under no circumstances can be permitted to override the directions passed by this court unless and until the finance department seeks for appropriate orders seeking modification or alteration of the orders passed by this court in WPC number 335/2021. Mr. Ibotaku submits that an affidavit in that regard shall be placed as to who is actually responsible for delaying the payment of the amount, for dispersing the amount to the petitioner. This matter on 27th of October 2025. The affidavit be filed by 22nd of October.
Well,
Payment has been made on, and he has received on 24th of September, day before yesterday. This is the instruction, if your lordship,
It has been submitted by Ms. Yuda, the learned petitioner, senior government advocate, that the amount has already been paid to the petitioner, and therefore the order passed by this court on 13/5/2025 in WPC number 453/2025 have been duly complied with.
and he has received the amount, the last page of
In
the
that regard,
last
she has placed a set of instructions
last page,
issued by the District Commissioner cum Chairman, District Disaster Management Authority, Dimahasau District, dated 24/9/2025. The same is kept on record and marked with the letter X, taking into account the above. Nothing further remains in the instant contempt proceedings, for which the contempt proceeding stands dropped.
thank you. Supplementary item 22.
Yes, where is Mr. Bottagol? He was here, na? Yes, Mr. Bottagol, anything done?
Yes, madam, we have. This an admission.
Directed to be carried out, be made within 1 month. You have carried out the verification?
Verification done, my lord. That is a report. 13.8 lakhs has been admitted.
Where?
And at the bottom of the table, my lord will.
13.855 lakhs have been found, na? So this verification is done, but and the same be released to petitioner within a reasonable period, but not later than. So therefore, we do one thing, as you have verified this only today.
Yes.
Give you another 3 months. We have this matter after 3 months.
Right.
You know, in the meantime, you make the payment.
Payment.
The 3 months, otherwise, my lord, the order in the writ petition, that 3 months period is over, my lord. If they want to take another 3 months, then that is another estimate.
No, says that within 1 month to carry out the verification.
Yes,
They did not carry out the verification. Now they have carried out the verification.
they have delayed.
And then, and the same, and from the date of receipt of the certified copy, and he found it treated the same be released to be there within a reasonable time, but not later than thereafter. So verification done now. So 3 months thereafter.
The 10/3 we submitted the certified copy, so they were supposed to do it
So
within
there
1
was
month.
a violation as regards
Yes.
not carrying out the verification. Now they have complied with that, made the verification.
Well,
Isn't it? Pursuant to the order passed by this court on 10/9/2025, Mr. Ibot Thakur, the learned standing counsel of the PHE department, have placed before this court an instructions, a verification report. The said verification report is kept on record and marked with the letter X. From a perusal of the said verification report, it is seen that the petitioner, it has been duly verified that the petitioner is entitled to an amount of rupees 13,85,500. Mr. Ibot Thakur submits that the same would be clear in terms within a period of 3 months from today. Taking into account the above, list this matter on December 17th, 2025 for an update. This court shall consider issuance of notice as to whether any notice is to be issued in the instant proceedings on the next date.
23. On the last day, the instruction was sought for.
It is pending at our end, my lord.
When by next date you will complete it.
Yes, we did.
They are participating.
No, they are.
Ask them to ask them do the hearing and finish
We'll
it
do
off.
it, man. We'll do it.
You have filed an appeal to fix a date. And finish it off. You participate in the hearing.
So there is a policy, my lord, whether the policy requires personal. Anyway, my lord, if your lordship, personal hearing is there, my lord. Personal hearing is there.
Not saying it. Give a personal hearing and finish it off. I would not mention it as per
Yes,
your
yes,
policy.
yes.
Whatever, maybe give a personal hearing because otherwise that is the grievance. And these are questions of where a person has been debarred, huh?
Yes.
Disbarment or something to the effect of blacklisting. So these have a lot of civil consequences. Mr. Endeka, the learned counsel appearing on behalf of the respondent number 127 submits that the appeal is present pending and he has been duly instructed to inform this court that within a period of 1 month, the said appeal can be disposed of. Because taking into account the above, this matter again on 27th of October 2025. This court further, this court, the petitioner herein is also given the directed to participate in the said hearing in the appeal proceedings so that the appeal proceedings can be, the decision in the appeal proceedings can be brought before this court on the next.
Yes. Obliged.
Happy Puja.
Obliged.